flew home on Thursday to see Rosie, and then flew back up here Thursday night, and then Friday I drove home after a session, and then Saturday I got up in the morning, drove to Rome, and then drove to back to Atlanta, stayed the night with Brody. Me and Brody stayed at the apartment. Got up at 4:45 Sunday.
So real quick to see now.
Okay. All right, good afternoon. We're going to go ahead and get started. Welcome to Judiciary Non-Civil Subcommittee. We're going to take up SB 465 first. Chairman Goodman. Hi. Sure. Thank you. And you can proceed when you're ready.
Mr. Gus Walters to please come up and sit with me.
Of course.
Gus is Austin's father that the bill is named after, and Austin's mom, Beth, is over there. The way this bill came about, Gus is a longtime friend, constituent, started emailing me in January of 23. And he would email about once every month, and I would trying to figure out what we can do with the fentanyl crisis. Their son, Austin, bought some Xanax that was laced with fentanyl and passed away within about 12 hours of when he took the medication. And so I began forwarding those emails to the Lieutenant Governor and to his General Counsel, his Chief of Staff, and every email that he sent I would forward and say, what do y'all think we can do? What can we do to address this? And that's where SB 465 came from. If you don't mind, I know Whip Burchett has helped us with some substitute language that you all have before you today. But if you don't mind, I'd like to allow Mr. Gus to speak. Mr. Gus, would that be okay, Madam Chair?
Sure. And before he does, let me just make sure we have, can you read the LC number that we should be looking at?
It should be LC 560173S, I believe.
Okay. All right. Yes, go ahead.
All right, thank you.
Can you hear me? Thank you, Madam, and the committee. Thank you, Russ, and the Lieutenant Governor. We've been stuck in this place that we don't want to be in. We don't want our Austin's death to not serve a greater purpose. Our Austin was a lovable guy. He never met a stranger, and he loved the outdoors. He sold John Deere equipment for Ag Pro, and he loved every minute of it. He loved his customers because they were his kind of folks. He was good at his job. Within the first 6 months being with the company, he was one of the top salespeople in the country, and he had found his passion. It was 5:30 on Wednesday afternoon, September the 8th, 2021. I had just gotten home and was fooling around in the yard Beth came running outside frantic and hollering that Thomas, our youngest son, was on the phone and something was terribly wrong. I got on the phone and all I could hear was my baby boy frantically saying, "Something is wrong with Austin, something is wrong with Austin," over and over again, and Thomas was on his way to my house. He pulled in the driveway about the time I hung up. We jumped in my truck and headed to Brunswick. From Valdosta, on the way to Brunswick, everything is mostly a blur. I remember Thomas telling me that Austin's roommate had found him unconscious on the floor in his bedroom, and he had called 911. I felt a kick in my gut. My heart sank, and I began to pray that everything was going to be okay. Austin had stayed home from work that day. He had what he thought was food poisoning, and we had talked several times during the day just to make sure that he was going to be okay. I spoke with him at 5:30 that evening, and he sounded a lot better. And he said, "Pops, I just need to get some sleep, and I'll feel better in the morning." I drove like crazy to get my hands on my baby boy. During our drive, we learned that Austin was non-responsive when they found him, and the EMTs were able to revive him before taking him to the hospital. I thought to myself, there's hope. His heart was still beating. We arrived at the emergency room, and I was escorted back to where Austin was. Thomas, his little brother, couldn't go. He was too scared. I walked in the room where my 30-year-old son, with everything in the world hooked up to him, laid, and there were 2 or 3 nurses and an ER doctor working feverishly trying to keep him alive. All the machines were beeping, people adjusting IVs and pushing intravenous meds, and scared me to death. It was then that I realized my baby boy, my first son, was lying there struggling to stay alive. I went to his side and I was in shock. All I could do was rub his soft beard, brush his hair out of his face. He had the best beard in the family. It was so soft and full, and he wore it like a man, but he was my baby boy. I prayed, praying that this nightmare would end and he would be fine, praying that suddenly he was going to open his eyes and say, "Hey, Pops." He started calling me Pops when he was in middle school. He actually gave me my grandfather name before my grandkids did. I just knew he was going to wake up and say, "Hey, Pops," because he was such a prankster, but he didn't. He lay there in the ER bed for 4.5 hours, and I spent every minute with him except when I went out to check on Thomas. I prayed over him. I talked to him. I laid on his chest and kept running my hands through his beard and his hair. And I cried like a baby for hours. I can still feel his beard and his hair in my fingers. It's so real. I didn't want to leave my baby boy alone. He needed me. Thomas came in a couple of times to see Austin that night, and for me it just made things worse. His best friend, his protector, his big brother, was lying there helpless, lifeless, struggling just to take a breath. It was heart-wrenching. Due to the swelling in Austin's brain, he had to be transported to Jacksonville to a neurosurgeon who could possibly save him. Before we left Brunswick, the doctor told me he suspected fentanyl poisoning, that they had seen plenty of it in the ER. He told me it was going to be a miracle if Austin made it. My prayer life changed that night. They were going to air flight Austin to Jacksonville, but they couldn't because of the storm, so we went by ambulance. And because we were in the middle of COVID, we couldn't go to the hospital because they didn't allow visitors. The nurses in Brunswick were angels that night. They were everything you could hope for in the human image of God. The doctor that night was just as divine. Thomas and I drove home that night. We prayed, we talked, we played songs Austin loved. He loved country music. We slowly came to realize that things in our world were never going to be the same. The next day, our real nightmare began. I had personally written my phone number on the transfer orders and asked for the people in the Baptist Hospital in Jacksonville to call us when he arrived. We never heard from them. We barely slept that night. As of 7 a.m., we'd not heard anything. I called 3 or 4 times, still nothing. We didn't even know if he'd made it okay. We finally heard from someone at the hospital, and they made arrangements for us to talk to a neurologist. The neurologist called and gave us the worst news ever. Austin's brain had suffered over 100 strokes. His cardiac arrest, he was unconscious too long before they brought him back. So we had to make the decision that no parent should have to make. Our Austin was not a drug addict. He was a lovable guy who loved to cook and fish and hunt. He loved people, and he loved his dog. He had a great job and a bright future. He took an occasional Xanax for depression. Unfortunately, he bought them off the street, always from the same guy. He had no idea he was going to die. He was all about living. It's been 28 months since Beth and I lost Austin. As a family, we're still trying to find a new normal. I read something recently that best describes this grief journey. The death is a date on the calendar. Grief is the calendar. It's been hell, but God has never left us. We both feel that Georgia needs additional laws in place to curtail the rampant distribution of fentanyl and other dangerous drugs. This is part of another email I sent Russ. I said, Russ, I know you're very busy. I know that you're passionate about important things in life. I also know that being a farmer, life is a crapshoot when it comes to bringing a crop into full harvest, much less maintain a farm the rest of the year. I'm here to tell you that our children's lives should not be a crapshoot. We have the ability to put laws in place that severely punish people for selling drugs that are laced with deadly drugs that cause the death of an individual. I don't want anybody to join this club. I can promise you, there's nothing worse than losing a child, especially senselessly. Please, let's put something in place to punish the people to the same extent that we feel punished. Thank you.
Thank you for sharing. I know it's really tough, and I'm sure it's tough to be here and share that story, but it does help, and we're grateful. Thank you. Chairman, I want to make sure that the members have an opportunity to ask you questions before we get to some of the people that have signed up. Would you like to go by this LC, or does the whip have a different version? I see. That is the, okay. Got you, thank you. Any questions from members? Chairman Smith?
To my good friend from South Georgia, Chairman Goodman, good to see you in front of the subcommittee.
Mr. Chairman, it's good to see you. I'd feel a lot better if we were talking about cows instead of law, but I'm going to do my best.
Well, you know, both are very stubborn unless you get the head pointed in the right direction. So,
That's right.
just a question. The circuit that you live in, have you seen any prosecutions for felony murder for deaths such as what occurred here?
Not that I know of, but I will tell you that after Mr. Gus began emailing me about this issue and we went to work on it, I went to doing pretty good bit of research on it, and I believe in 2022 there were 106,000 Americans that died from drug overdoses, and over 70% of them were attributed to fentanyl.
Right.
And I believe that same year there were 2,400 Georgians that died from fentanyl poisoning. And these folks, I've had emails. Miss Stephanie emailed me, her son Ryan died. The same fellow that sold Ryan the drugs that he died from has sold drugs that have killed 3 other young people.
Do you know what he was charged or convicted with?
I do not, but the amount of mothers and parents that I've had email me and text me and Facebook message me.
Who's your district attorney down there?
Chase Studstill, where I live at. I actually live in 3 different district attorney circuits, but Chase Studstill represents the county that I live in.
Gotcha. Okay. And who helped you write this bill over in the Senate?
Primarily the Lieutenant Governor's General Counsel, and we also had input from district attorneys as well, but primarily Brad Vaughn and Lieutenant Governor's office.
Okay. I'm not familiar with their experience. Do you know if those that were from the Lieutenant Governor's office had any experience with prosecuting drug cases or drug overdose deaths?
I have Jack Winnie from the Coweta District Attorney's office. He's the chief assistant, and his boss, Herb, is here actually, and Herb can come and give more insight into the particular line of questioning you're asking about. But
Thank you.
Herb, would you mind?
Sure.
All right, I have your mic on. Thank you for coming.
Thanks. Is there something you want me to directly address or just kind of touch on
Yeah,
some of the stuff
I'll
you're
ask
asking?
you, since you're one of my home DAs, how many felony murder convictions have you obtained in your circuit for fentanyl drug overdoses?
I believe we've indicted a few, but we didn't resolve them as felony murder. That's very difficult based on the evidence.
Okay, I just, that's interesting to me because I know District Attorney directly north of you, Jack Browning, in my home circuit, he's obtained felony murder convictions for fentanyl overdoses. And I believe that now Judge Zamir Patel, when he was a district attorney, he actually obtained felony murder convictions for those that had distributed fentanyl that ended up in an overdose and killing the victim.
I'm familiar with Haralson County recently got a conviction for involuntary manslaughter that on a case that was indicted as felony murder. And I've spoken to the Cherokee DA about his case up there. My understanding is, you know, the problem with proving felony murder in these kind of situations is you have to prove the dealer knew the substance that, you know, in this case, fentanyl. So if we couldn't prove that a dealer knew there was fentanyl and what he was selling is Xanax, we wouldn't be able to prove felony murder. And I think this bill addresses that. What I see is the major problem with using felony murder to hold drug dealers accountable for giving people fentanyl. And I think this will be a very valuable tool in our belt. Compared to involuntary manslaughter, the maximum punishment for involuntary manslaughter is 10 years. And this gives us a punishment range basically right in between involuntary manslaughter at 10 years, felony murder is at life, and this gives us, if I recall correctly, 10 to 30 or life. And we don't have to prove that the dealer knew there was fentanyl in the substance he was distributing. I think it'll be an incredibly valuable tool to have, candidly.
Okay, there's a concern that I have. Let's say this bill's enacted as introduced here, that we go from having the felony murder statute, which we can actually seek the death penalty under, and we go to not less than 10, no more than 30 years or life imprisonment. Have a grave concern. We will never see another felony murder case brought against someone dealing fentanyl in this state that kills someone. That is the concern that we have here. I understand it may not be the easiest case to prove. However, it has been proven in the state that you can obtain these felony murder convictions for those that deal this deadly poison to our citizens. I understand the intricacies. You have one of the toughest jobs in the world, and I commend you for it. But that is a huge concern here with this sort of, what I would say, soft penalty. And I would ask the author this question: would you be amenable to increasing that punishment range?
I think so. I think right now you're having to prove in order to get, and I'm not an attorney, you know that, Mr. Chairman, but you're having to prove that the person knew that what the substance was. But as I stated earlier, 70% of the deaths that are taking place is fentanyl. These people that are spreading this stuff in our communities, they know dang well that there is a very good chance that it's got fentanyl in it. So with felony murder, having to prove that they knew that, so many of these people, I think that this is a punishment, and I don't know how many people have been sentenced to death for selling drugs that have killed somebody, but 30 years to life in prison is in my estimation. Do you know if anyone, Mr. Chairman, has been put to death for selling drugs to somebody that caused the death? I don't.
Not as of yet. I know that the fentanyl crisis that we have going on in the state probably hadn't been long enough. I know the next person up on death row, that was for a conviction in either 93 or 94, so you're with the case is being investigated. My question to the author is, are you opposed to increasing the penalties?
No, sir.
Okay. that you have written here?
No, sir, I'm not. No, sir.
Okay.
And I think I can speak to maybe some of the concern you've given. If a DA had the evidence that a dealer knew they were dealing fentanyl and fentanyl caused the death, they could still pursue felony murder. This wouldn't preclude indicting somebody and trying to get a conviction for felony murder, which requires at least a life sentence.
I don't disagree with you there, but the concern that I have is that you will not see it. This is the easiest path for a conviction now if this is enacted. And so that ultimate penalty, that ultimate deterrent for those that deal this deadly poison, I'm afraid we'll never see it. I mean, we've had cases in our West Georgia area that many of us feel like should have had a death penalty sought because of the murder. And it wasn't done, wasn't even pursued.
Mm-hmm.
That's the same kind of concern I have here, is that we will never see this again. So just trying to see if we can increase the penalty here at the very least to let us know that we still take this very seriously.
Mr. Chairman, could I ask, is one of the reasons that it wasn't pursued was because they couldn't prove that the person that was selling it knew that it had fentanyl?
I was relating to the death penalty as a whole in that
Okay.
scenario.
Okay.
And just for the chairman's record, we had a bill similar to this come up last year, and we had a couple of DAs that actually testified that they could go after these people under the felony murder statute without hesitation.
And I would be very surprised if there have been even 10 felony murder convictions in the state of Georgia for, somebody dealing something that had fentanyl in it. I would be shocked if that was more than single digits. And when you compare that to, I think you said the over 2,000 deaths,
2,400.
my perspective is the tool of felony murder doesn't get us to where we need to go in terms of being able to widely prosecute drug dealers who are dealing things that whether they know it or not, have fentanyl in it.
Could I ask a question of the chairman? 'Cause isn't there, in other cases, isn't there aggravated involuntary manslaughter and murder 1, murder 2, murder 3, and all that kind of stuff? Is there not? In other instances where somebody's caused the death of somebody? So, I mean, there are different ranges. Look, there again, we're talking about cows, but, there is a range. This gives, and I guess the way I look at it, and if this law helps put somebody in jail that saves lives, and that we know by just what the dialogue that y'all been having, the barrier that it takes to prove felony murder, and this person gets put in prison and it saves a life, me as the author, I'm okay with that. Does that make sense?
It does, and I mean, that's this committee's understanding for the past year has been that we already had a law on the books to accomplish this. It's just that district attorneys were not going after them.
Well, I would say, and tell me if I'm wrong, Mr. Chairman, but is it not true, and this is one of the reasons, I guess, this law is going to, they're not going to be able to hide behind saying that I didn't know that it had fentanyl in it anymore. Mm-hmm. Because if you know that over 70% of the deaths that are of drug overdoses are attributed to fentanyl, the people that are selling this stuff, they know dang well that there's a good chance it could be laced with fentanyl. I think that's the point of this bill, is that these drug dealers, these people that are spreading this poison in our communities, they can't hide behind saying, oh, I didn't know that it had fentanyl in it, because just the state of affairs that we've got right now, anyone that's selling this stuff knows that there's a good chance it very well could be.
Yeah. The most recent conviction in our circuit, we pled down to involuntary manslaughter and drug distribution. It was a 30-year in prison sentence followed by 20 years on probation, but only that first 10 is going to, be a level 8 parolable sentence, and so we still expect that person, good chance they get out before 10 years. Whereas this, if aggravated involuntary manslaughter is treated as a level 8 offense, just like involuntary, and felony murder, or murder second degree, then they would have to do at least 65 to 90% of whatever the prison sentence is here. So I think this does provide a much tougher sentencing regime than is currently being used in the state of Georgia, given the difficulty in proving felony murder.
All right, thank you. Whit Burchett.
Thank you, Madam Chair. To my friend from South Georgia, thank you for bringing a not a cow bill or cattle bill or an ag bill, and I appreciate you wading into this this subject matter. It's a tough subject matter, and as you can tell, in Judiciary, we really get down to the the nitty gritty right away. And thank you, Mr. Chairman, for hearing the bill. In our talking about what this bill does, in the first version that came out of the Senate, one of the things that was in the Senate's version, and I want to make sure, Madam Chair, we're all on the same substitute and everybody's looking at the same one. So we're looking at LC 560173S. Is that correct? That's correct. Everybody has it, okay. So currently, the problem as I see it is we have a significant amount of our young people and old people and just all of our Georgians, period. Just had one this weekend, not this past weekend, but the prior to this past weekend, I had an overdose death of a family friend of mine's son. I'm confident in saying that it's likely due to fentanyl. And we've seen a growth in this country and in Georgia with a, I don't know what folks are running from, but they're taking this strong opioid and they're mixing it up with any kind of drug you can. And it'll kill you. As I'm told, fentanyl will kill you if you touch it. It can go through your skin and it will kill you. So this is a problem. It's a pandemic. It's a pandemic across this country, and we've got to do something to hold these folks accountable that are continually dealing this stuff. It's illegal in the state of Georgia to deal drugs. I think everybody knows that. But if we've got a law on the books, like the chairman said, felony murder, that we cannot reach these folks. 70% of the deaths in the state of Georgia, as you stated, were on account of fentanyl overdose, and we've had maybe 10. You said maybe 10.
I'd be surprised if it was 10.
Felony murder convictions. Well, the problem is that you've got a mens rea. You've got a intent. You have to intend to have sold fentanyl. You have to know. Well, how do you prove that? How do you prove that? Unless you've got, text messages where I understand we did get a felony murder charge on a fentanyl overdose, when you've got a record of someone saying, hey, that's a bad batch, throw it away. Hey, that's a bad batch. So that right there, that's intent. They know there's problems with the drugs that they've got. And I think that's how you can get to a felony murder charge. But the problem is that you can't do that with everybody. If someone is pushing this stuff out, there's no record that they know about what's in the drugs, then how in the world do you get a conviction? Well, the best you could do, I could think, is threaten felony murder and then plead them down. And that's probably what's happening. So as I see this, and so in talking about this bill, and when Chairman Goodman brought it to me, I thought, heck, this is going to be an opportunity for us to have a tool in our toolbox to really get after the folks that are out there pushing this and peddling this awful substance. And so the things that this bill does do, I'll run through it, is this. One, this is strict liability. This is strict liability, and it takes away the mens rea requirement. So one of the things that we did in Chairman Goodman's provisions, he had a intent to distribute and deliver. Well, for me, that's a very high bar, right? So I could see where someone delivered a marijuana cigarette on campus somewhere, and they smoked it and somebody else smoked it with them, unknowingly having fentanyl on it, and somebody dies. And that seemed too harsh to me if it was a marijuana cigarette. So one of the things we did in this piece of legislation is remove delivery and removed distribution. So we left manufacturing and selling. Manufacturing and selling. So if you manufacture something, you know what's in it. Would everybody agree with that? Well, you know. You have a knowing component there to say, hey, I'm mixing up whatever this drug is with this deadly drug that you can overdose on like that. And when you do something like that, just in my practical opinion, you are putting folks at risk. Well, first off, if you do any of these drugs, you're putting somebody at risk if you're manufacturing or selling them. But if you're adding this in there so there's another degree of high for folks, then you should be held accountable for it. And currently, under the current code and under the current law, there's a way to do it, but you can't do it unless you can prove something that's almost unprovable. You can't prove what they knew. So you could die. So you could charge felony murder, as I understand it, and you could die of an overdose of cocaine or heroin, and it has fentanyl in it. But because you can't prove that you knew there was fentanyl in it, you can get off without you can get off of a charge for felony murder. So that's what this seeks to fix. If you're out there dealing, if you're manufacturing or selling drugs that have fentanyl in it, we're coming for you. That's what we're saying. It's as plain as simple as day. This gives it's a hammer. It's a hammer. And for parents like these and all too many of them that are calling me, coming to my place of business, they're pleading with us. Please figure out a way that we can stop this. It's coming in manufactured Xanax, oxycodone, any type of opioid pill. They're actually making fake pills. They're making fake pills. Folks, I'm nervous enough taking a pill from the pharmacy. These folks think they're buying pharmaceutical grade drugs on the street, and they're getting a knockoff that has fentanyl in it. And that's what's happening. You know, I'm not saying that we should condone the use of drugs or condone the use of opioids or any of these drugs. What I'm saying is that we don't have a tool right now to get after the actual people that are making these drugs and selling these drugs. That's what this bill does. If anything, the only way that you can really characterize this bill is being hard on fentanyl. We narrowed it to fentanyl too. That's one of the things that the chairman allowed us to do. Early on, it was for every substance, illegal substance under the code section. We exempted marijuana, and we narrowed it to fentanyl. So if you pass off a fake oxycodone or a fake opioid or a fake Xanax with fentanyl in the pill, then you're gonna sit before a judge, and it's gonna be easy. The district attorney does not have to prove that you knew it had fentanyl in it. They don't have to prove it. That's the key piece, folks. You do not have to prove the fact that it has fentanyl in it. You should have known better than sell a fake Xanax. You shouldn't have manufactured it in your garage, added fentanyl to it, so somebody unknowingly takes the thing thinking it came from CVS or somebody's prescription, and they don't wake up. They just die. That's what we're after. I mean, it's not a scenario where we don't want to see felony murder charged again. And in my opinion, because we've narrowed it to fentanyl, and because we've narrowed it to only manufacturing and selling, you can charge felony murder if you knew that you were selling a bad batch of cocaine and the cocaine had something other than fentanyl in it. You can charge felony murder if you knew that this drug was killing people. I think this is another tool. It's not taking away the ability, and you can get 10 to life, and we do need to give our judges discretion, because there will be something we cannot, as a body or as members here, we cannot predict what scenario we're not thinking about. So we have to give some discretion, some judicial discretion. The other thing that's in here that is a hammer, in my opinion, that is hard on crime, is this does not merge. So you don't merge this. This is a charge in and of itself. If you look on lines 31 and 32, the offense of aggravated involuntary manslaughter shall be considered a separate offense and shall not merge with any other offense. So that you can't. You can have felony. You have this aggravated involuntary manslaughter. You could have possession. You could have whatever else, possession of a narcotic. So you're going to get charged with that and this. There's no merging of crimes here. So that, as I see it, is what the bill does. And I think we do have to, at some point, take a stand on what's going on. I mean, fentanyl is a problem. There are certainly probably someone out there that is going to testify or say that they are utilizing fentanyl as prescribed by a doctor and in a dose that a doctor has given it, and they've bought it somewhere at a pharmacy. No, this doesn't touch that. This doesn't touch that. Legal use. We're talking about illegal use. So that's my pitch. I appreciate you, Mr. Chairman, for bringing this bill. I appreciate you guys letting us work with it. I appreciate the LG letting us work with it.
Yes, sir.
To make it get after the acts that I think we're after, and not capture some of the things that I don't want to capture. But strict liability, folks. That's it. You get caught with it. You're selling or manufacturing. This is a hammer. Thank you, Mr. Chairman, or Madam Chairman.
Thank you, Representative Miller.
Thank you, Madam Chair. Thank you for your bill, and to Austin's family, my sincere condolences on your loss. No questions that we ask here today are meant to minimize that at all, okay? I did have a question, perhaps for DA Crandall might be better suited to answer this. If we, and I understand the philosophy, I get it, I understand we're somewhere between felony murder and what we're trying to capture here. With the life component on the end, so we got 10 to 30 or life, is there any concern that sort of as a matter of like fundamental precepts of criminal law that we have mens rea, we have intent, and we have the act, and that if we're going to give someone the ultimate penalty, okay, less than death, life, can you talk me through why that would not be concerning for you? And I'm not talking about the 10 to 30, I'm talking about the life part. That when we say life in prison, it usually means that you have both the actus reus and the mens rea.
Mm-hmm. I think I see what you're asking, and one response that occurs to me, if I recall correctly, I think you can currently get life for distribution. And you know, I think I and other DAs would be very judicious in deciding what defendants who committed this crime deserved life. You know, I think people with criminal histories, you know, that are essentially what I would be thinking at least is, you know, people who are preying on addicts to make money and are happy to distribute things that may have fentanyl, that may cause people death, and they're doing it, you know, repeatedly. I think some of the worst of the worst, life could be an appropriate punishment. But I think one of the reasons I really like the bill is that it does give a wide range, you know. But I do think there are going to be people that are deserving of a life sentence for this act, even though it doesn't require an intention to kill.
One follow-up, Madam Chair. So if, and I stopped prosecuting long before this really became the epidemic that it is now, but how would you prove, for example, if a person took a pill, right, and they overdosed on the pill, that the person who took, how do you prove causation? In other words, how can you determine where the fentanyl in their system came from? So if we know that the last thing they took was a pill that they had gotten from a person that they regularly buy them from, how do we know that there wasn't any sort of intervening thing that would trace the fentanyl that caused their death to the pill that someone may have sold thinking that it was just Xanax, for example?
If you're making the point that the fentanyl in their body that caused their death could have been from another source, I suppose that could be a defense. In my experience, in a case that I'm aware of in my jurisdiction, typically a user is they don't just buy a single use, right? But when that single use has fentanyl in it, they die. And so there's typically, like the case I'm thinking of, a bottle of pills next to the bed where they were found that's got another 3 pills in there. And so those get tested, those have fentanyl in them. And, and typically there's somebody that knows, a friend, they had just picked up, some stuff from their dealer, earlier that day. But the state still has to meet a burden beyond a reasonable doubt, and there could be defenses that we have to get over, and I have no concern about that because that's a burden we live with every single case, and I still think this is a really valuable tool, despite the fact that there may be defenses we have to overcome.
Can I add to that? I'll just say, as a non-attorney here, there's not a mandatory minimum here, but if you've got someone that's been arrested twice and served 2 prison terms for selling drugs, and they get out and they sell some drugs to a bunch of 17-year-old girls, and 3 of them die, but you can't prove that he knew that it was fentanyl, I think that person deserves to have life in prison after the life that he's lived up to that point, and he's caused the death of 3 young people. That's my non-lawyer view of it.
Thank you, Representative Crowe.
Thank you, Madam Chair. More non-lawyer portion of the proceedings. And I think I'm going to ask the DA real quick. Back to what Chairman Smith was kind of alluding to earlier, and why felony murder doesn't work, or why it can't work for what you're talking about. And I think you said you'd be surprised if there were more than 10. You said typically when they were charged with felony murder, those got, I guess, pled down, or they got sentenced or convicted of involuntary manslaughter or voluntary manslaughter, because voluntary manslaughter is a lesser included of murder. Correct?
Yeah, that's an important distinction to make. So voluntary requires like provocation. That's where somebody gets upset with somebody, heat of the moment, kills them. Involuntary manslaughter is based on reckless conduct, like negligence. And so most of the cases that I'm aware of, and again, I'm not aware of many indictments for felony murder for these kind of facts, but I'm aware of at least a few cases that were indicted for felony murder based on we have enough probable cause evidence to indict, but when it comes to proving it beyond a reasonable doubt, the decision is made to plea it to involuntary manslaughter, which is a lesser included offense, particularly in light of these facts, and so that's what my office did recently on such a case. That's my understanding of what happened in Haralson County, indicted as felony murder, but a plea was worked out in Haralson. I think it was 15 years in prison followed by 15 years on probation, and I'm glad they were able to do that. But again, my concern is only 10 of those years are going to be based on involuntary manslaughter, whereas here they could have done the whole 15 based on aggravated involuntary manslaughter. Or in my case, we got a 30-year prison sentence. The whole 30 could have been for this, and parole would have been based off, that one portion of the sentence versus just 10 years of it.
Right, okay. And involuntary is a 1 to 10 year
That's right.
felony, and this would be 10 to 30 or life. And to my friend's point earlier about the concern about the life and the mens rea, I think that if they're selling anything, whether it's laced with fentanyl or not, if they're selling these illicit drugs, knowing there's a chance that it has fentanyl in it, but even if it don't, they have a gross indifference to the life of that person. So I don't know that intent is that hard to get to. I don't think they care whether that person lives or dies if they're selling that stuff to them, regardless of what it has in it. So thank y'all for bringing the bill.
I think it's important to have the options. You know.
Chairman Smith.
District Attorney Cranford, how many felony murder cases have you sat first chair on, tried and convicted?
I think I've personally tried 2, maybe 3.
Okay. And was the death penalty given in any or sought in any of those?
No.
You didn't seek the death penalty for those? But you could have, right?
There have been cases where I could have sought the death penalty. I don't know if it was the cases I went to trial on, but there have been cases. Typically, every case I can think of where I could have sought death, the defendant agreed to do like life without parole.
Okay.
So like the ones that went to trial they didn't qualify as death penalty cases according to statute.
All right, any other questions from members? All right, I don't see any. Thank you, District Attorney Cranford, for being here. If you can stick around, I'm sure we may have some questions later.
No problem.
But I'm going to go ahead and start calling up some of the ones that have signed up, starting with Angela King. Good afternoon. If you can state your name and who you're
Yes.
with. And
Yes, Angela King. Thank you, Mr. Chairman, Madam Chairman, committee members, Senator Goodman, and Lieutenant Governor for making this a priority, Representative James Bruchette for carrying Senate Bill 465 in the House, and a special thank you to the Walters family and Amy Odom for all your hard work and support and for the opportunity to share Jack's story. Jack is my son. And I also want to thank my husband, Mike O'Kelly, who cannot be here today. This is Jack. "20 years old, junior, University of Georgia, tremendous athlete, captain of his lacrosse and football team, worked out every day, straight A student, big heart, positive, caring, wonderful friend, son, and brother to his siblings, Pano, Lucas, Jamie, Sophia, and Anna Kate. That's what we have left of Jack right now, are those memories and his urn of ashes. No more birthdays, no more holidays, no more UGA games with his father, beach trips, time with friends and family. No opportunity to get married and be a father one day. The night before Thanksgiving in Atlanta, especially, all the college kids come home and it's a big night out. Big night to go celebrate and reunite with your friends. Everyone went out that night, all of our children. And I have everybody's location on my phone. I always check, and we all stay up to make sure they all get in. Woke up in the middle of the night and saw that Jack had spent the night at a friend's house right around the corner from us where we live. We woke up Thanksgiving morning, ready to celebrate. One of Jack's favorite holidays. My husband started calling Jack in the morning to come home to get ready, and Jack didn't answer his phone. He called the parents, and they said, "Oh, we just looked in, and all the boys are still sleeping. Come on over. We're going for a walk at the park. The front door's open. Just come on over." So he drove over, and a few minutes later, he called me in a complete panic. "Jack's gone. Jack's gone." I rushed over, and when I arrived, the police and the EMT were there. My husband had worked on him for 30 minutes, and he told me his fingers were blue, he was already cold. The EMT worked on him for an hour. All of our children came over that morning. The screams, the wails, the absolute terror, shock, fear, and pain that we endured that morning. No parent, no sibling, no human should ever have to experience. It was the most devastating day of our lives. Jack took one pill that night with his friends, having a good time. One pill that killed him. He had no intention of dying. He had so much going for him. We all make mistakes. As kids, we make bad mistakes, bad decisions. But he shouldn't have died from this. We are grieving, we are hurting, but we have to turn our pain into purpose. I have to save lives. This bill is very important. It is a first step. Fentanyl is killing. Every 5 minutes, someone's dying from fentanyl in this country. 300 people a day are dying of fentanyl in this country. It is the number one cause of death for people 18 to 45. This drug does not discriminate. I'm speaking my story for Jack because he was 20 years old. This is happening everywhere. It doesn't matter how old you are. There has to be change. We have to do something about this. It is going to get worse. Boatloads of fentanyl are coming into this country daily. Just last week, 5 people died in little 5 points of fentanyl, supposed fentanyl. I'll be surprised if it's not. They were adults having fun. It's common sense to start making and starting these laws. We have to hold these drug dealers accountable. Why are we giving them the benefit of the doubt? They're dealing drugs that are killing our children, our parents, our friends, you name it. Something has to be done. And I'm willing to do anything and everything in my power to end this. We have a tremendous crisis on our hands. This needs to be on the front page news, on the news daily. We have to start talking about it. Please talk to your children, to your friends, nephews, cousins. If you don't have kids, start talking about it. It's going to happen again and again and again. We all are responsible. We're all connected. We're all living this life together. We've got to help one another and spread the word. This has to end. Thank you for this opportunity to speak today. And I ask for favorable consideration for Bill 465. Thank you.
Thank you. Thank you for sharing. Justin Leaf is next. Do you have Robin Elliott with you, or you two want to
Sure, we can probably speak at the same
speak
time. Yep.
together? Sure.
Good afternoon, everyone.
If you can share the mic, I guess one.
This one right here?
Sure.
Perfect. Good afternoon, everyone. My name is Justin Leaf, and I'm here today to kind of start with the end, especially for the parents we just heard from, Gus and Beth. I feel like hearing Austin and Jack, who they were, I would have been friends with them. 10 years ago, I came before this body after serving as an intern and as an aide, saw how the legislative process worked. I truly saw it, the good, the bad, the ugly, concessions, things getting done, right? More than 10 years ago, I lost my best childhood friend, Zach. His mother is sitting next to me. His death was avoidable. The person using drugs with him, instead of calling 911, left him to die. So I'll start for the sake of these parents behind me who I've now become a parent since I worked on this bill twice over. We want to do what you want to do, which is to save lives, to continue to encourage action and good faith to save lives. 10 years ago, when I set out to find that narrow gap to give immunity for friends using drugs together to call 911 for medical amnesty, the first thing we did was we worked with prosecution to craft legislation that did not protect those who deal drugs. We sought to protect, honestly, kids at a party, going to a concert, that use drugs together. At the core of the medical amnesty law that passed by this body 10 years ago, and Robin and other parents who worked on that bill were recognized by this same legislature just a couple of days ago. The spirit of that bill was to encourage action. If you have paraphernalia on you, if you have a personal use quantity of drugs on you, you were immune from prosecution in the way that valuing human life was put above a simple drug charge. A lot has changed. In 10 years, I've had 2 kids. It's put some gray hairs on my head, and I can certainly attest to how much that bond, my son's name is Jack, changes you. What's also changed is fentanyl. After working in prosecution for 18 months, seeing the great example set by those prosecutors 10 years ago, I served in Cobb County for 18 months and saw firsthand the intent of this tool that this bill offers prosecution. I saw it firsthand in jury trials, where having the right language and meeting that burden of proof is essential. Again, what's changed is fentanyl. I think the substituted version that I have not honestly seen a copy of that focuses this on fentanyl is a great focus change. What has not changed in 10 years is that advocates in the community that you heard from earlier, as well as what you hear from me now and Mrs. Elliott, we want to save lives. Those that are addicted to drugs, those that are recreationally using drugs, and those that are unknowingly taking a drug that's laced with fentanyl. What's not changed in the last 10 years is we again want to work with prosecution. Right now I'm on paternity leave, and I've called about 10 prosecutors that I've worked with or I've had good experiences with to see what this bill really does. I think the changes that have been made that we've heard from today, those are awesome changes. I think they get at the concerns that we had as it was originally written. And additionally, what's not changed is that we do not want to protect drug dealers. The scourge of fentanyl, I can say firsthand, after working in prosecution, I chose to go back into this sort of world of understanding what's happening in our communities with addiction. I worked for the CDC as a contractor for 5 years, managing close to $1 billion in opioid funding and grants. Law enforcement and public health working together is essential. So my goal today is to ask that this committee consider the amendments. I believe they will be, offered as a Sharon Cooper substitute. They're targeted. Either they, again with the other substitute, again, forgive me, I've not seen that language, focuses this on fentanyl. What again our concerns really came down to is people use drugs together in a way that I was concerned about, and I think this now resolves, which is if you're a drug dealer versus if you're And I'm going to be frank, you're going to a fraternity party, you're going to a concert, you're going to a bachelor party, and you're 30 years old. If someone buys drugs that just happens to know a person that sells drugs, and then 10 people at that bachelor party pay her back, where does that leave us? So I think the amendments that we made, or the substitute version, really gets at only that scenario. And what it additionally encourages is if there is any doubt about the intent of that person, it's up to the prosecution and to the judge to evaluate good faith. I think a couple of examples that were considered earlier really get at that. So with that, I think I heard this is a tool, take a stand. I agree with that. I think this is as much forward-looking for especially Jack, for his mother, about my kids and what future they face. So with that, I'll pause. Robin.
Hi, everyone. My name is Robin Elliott. I'm one of the co-founders of Georgia Overdose Prevention. This is my son, Zach. Zach died on May 1st, 2011 of an opiate overdose. He was 21 years old. And as Justin said, he and Justin were best childhood friends. I'm here in opposition to to Senate Bill 465 as it was written when I originally saw it. There's no one that wants overdose deaths to stop more than I do. If you're talking about manufacturers and dealers, sign me up. My son was sold drugs that forever changed my life and ended his. Justin addressed some of this stuff, so I'm just gonna, we worked diligently 10 years ago to pass the Georgia 911 Medical Amnesty and Expanded Naloxone Access Bill in the state of Georgia. That was the foundation, Representative Cooper's bill. Thank you, Sharon. That was the foundation for Georgia Overdose Prevention. We are a group of volunteers that work and travel the state to try to educate people on that law. Since the law passed, we've educated over 60,000 Georgians on the fact that it's okay for them to call 911 at the scene of an overdose and not be prosecuted for personal use quantities of drugs and paraphernalia. We have been told over and over again as we travel the state. I mean, I've been to colleges, universities, I've been to high schools, churches, I've spoken at rehabs, treatment facilities, MAT clinics, anywhere that really has invited us, we will go and tell them, teach them. We've been told over and over again about the lives that have been saved because people called 911 because they could. I'm concerned, peers use together, as Justin pointed out, and I'm concerned that the bill as it's written, if it doesn't sort of have a crosswalk with the 911 amnesty bill, that people will not call 911. And I don't think it will take long. All it will take is a few prosecutions to take place, and people will stop calling. Because if people didn't, when my son died, they didn't call 911. They didn't call because they were afraid they were going to be prosecuted for small quantities of drugs. Those would have been relatively short jail terms. Now we're talking about people that might be prosecuted for manslaughter or murder. If they wouldn't call for small quantities of drugs, they're more than likely not going to call if it's manslaughter or murder. So I just would hope that there could be some kind of a crosswalk between the bills to ensure that people still feel safe to call 911, because I'm afraid that this bill will wind up taking,
As it was written.
as it was originally written, will wind up taking more lives than it saves. So I just want to make sure, as I said, that people can call 911 at the scene of an overdose.
And if I can, a couple of points I wanted to make sure that we talk through is, in talking to prosecutors that are friends and looking through this, actually worked with the gentleman who was mentioned earlier that wrote this, working for Sean LaGrua in an internship in law school. At the end of the day, the edits that have been made and suggested to this bill, I think, take care of pretty much every concern that I would have. That includes a crosswalk with the amnesty law, making sure that there's a commercial purpose in distributing drugs. It exculpates, sadly, a scenario that might be playing out from Little 5 Points, where one person buys drugs for a bunch of people at a party or at a gathering like a bachelor party. So I think, to be honest, I look back at where and I think Gus's father mentioned this, I took the bar exam a week after Zach died. And I made it my purpose to do something with my education and access to this network in this community, in this building, to do something to save lives. And I think that bill has done that. I think the first week that bill was enacted and signed by Governor Deal, it saved a life with a law enforcement reversal in Cherokee County. And our real concern is just to make sure there is intent behind crosswalking these two pieces of very well-intentioned legislation. One just happens to already be on the books. And that's it.
Great, thank you. And I think that's a good point, and I think we're taking that into consideration. Any questions? I don't see any questions. Thank you. Thank you for sharing.
Thank you so much.
Andy Gish. Good afternoon.
Hi, thank you for listening to me. I am also with Georgia Overdose Prevention, and I'll tell you that I am a board-certified emergency room nurse and have been fighting this for 18 years. So I saw what it was like before, and I saw how having our medical amnesty law has changed things. We used to have people come in intubated. I was the nurse sitting with the families, which is why I got involved with this. It was too much. Once the medical amnesty law was passed, what would happen was people would come in sitting up on a stretcher, maybe arguing with me because that they didn't maybe necessarily need to be there because someone called and they didn't delay in calling. So this really has had a big change in the emergency rooms. And I'll say that it's so stressful in that situation, right? I've also lost friends. I have family members in recovery, and I have family members still at risk. So we just need to explicitly include and protect the medical amnesty law. This hasn't been announced yet, but Georgia Overdose Prevention has saved at least 10,000 Georgians that we know of. Many people don't call us and tell us that they've been saved, but of the people who've called us and told us they've been saved, it's over 10,000. And I just don't want to put those people at risk. I think that's it. Thank you.
Thank you. Sarah Fabres Cordero.
Hello.
Hi.
Hi, everyone. My name is Dr. Sarah Fabres Cordero. I'm assistant professor at Emory University, Nell Hodgson Woodruff School of Nursing. I want to start by dispelling a fentanyl myth. Just so everyone knows, you cannot overdose from touching fentanyl. It has to be introduced to your mucous membranes. You have to inhale it, or I had laryngitis last week, by the way. I'm always dispelling this. I'm a harm reduction neuroscientist. I worked with Georgia Harm Reduction Coalition and Georgia Overdose Prevention to make sure that people who need Narcan have access to it. We also teach people to never use drugs alone, to stay with people who can call 911. I am happy to see that the bill has been revised. We did have many concerns that have been addressed. I do still have a concern, though. I know sometimes when people who use drugs buy drugs, they will sell a portion of their personal drug supply. That is concerning to me, that people who use drugs, who need treatment, will be incarcerated because they bought a bad batch of drugs and they sold a portion of it to their friend who, by the way, wanted that drug. I've lost friends to overdose. I worked in Little Five Points, Atlanta for 20 years as a pizza waitress. I lost friends to unintentional overdose, and I understand the feeling that they were murdered. They bought a drug that were not seeking fentanyl, and they died of an overdose. Unfortunately, though, people who use drugs and buy any drug outside of a pharmacy, we all know we're in the midst of a fentanyl crisis. As a nurse, a harm reduction nurse, our supply is so dangerous. I would like to see interventions in the future that really talk about how we can provide more care for people who use drugs, provide safe supply of drugs. Why is it that someone who wants Xanax can't get a prescription for Xanax? I don't understand. Why are they having to turn to pressed pills? I do appreciate everyone working together to make this bill more focused. But again, how will you discern the difference between someone who deals drugs and a friend, a person who is a drug user who sells a friend a pill? Is that person going to be charged and go to jail for manslaughter? And again, that person, I mean, Georgia has been so progressive in our 911 medical amnesty laws. We have really been a leader. We have some of the best medical amnesty laws in the country. And thank you all for that. And thank you to Robin and Andy and everyone who worked to make those laws happen. But unfortunately, when this law goes into effect, people are likely not going to call 911 if there's not some kind of protection for them in our medical amnesty law. So thank you very much for your time.
Thank you. Maisie Lynn.
Thank you for hearing from me today. I'm Maisie Lynn Gerton, Executive Director at the Georgia Association of Criminal Defense Lawyers. And I don't relish being the voice to come and potentially sound like I'm trying to be easy on anyone in this space where people are dying. That is certainly not my intention. I certainly do not want to continue to see people dying of overdoses. What I would like to commend is a concept you all talk about in the human trafficking space frequently, and that is drying up demand. And I was really heartened to see Chairman Cooper here today, not only because of the 911 aspect that has been talked about, but also to hear the idea, to float and socialize, to begin to have you think about other ways apart from carceral measures to address what's happening in our state and across our country. Other states are implementing fentanyl test strip access. They cost about $1 a piece retail. It costs over $45 a day to hold someone in a Georgia prison. There are other mechanisms that you could rely on to stop this particular epidemic, this pandemic, however you would like to think about it, beyond incarceration, beyond life sentences, and beyond, which respectfully, Mr. Chairman, death penalty for strict liability punishment. It's most disappointing to hear that idea floated in this space today. Whip Burchett, I would like to come back to your conversation about knowledge, and I am grateful for some of the changes that have been made since this bill was introduced, and for all of the people that had to work to make that happen, especially what you outlined, where the idea of delivery and distribution has been removed in favor of focusing on the parties who are in, as you said, the best position to know what is going on with these substances, the manufacturers and the sellers. And the fact that they are in the best position to know causes me trouble that subparagraph F is included, which removes that knowledge component. You have outlined a policy that will apply strict liability. You do not have a mens rea requirement for the cause of death. I would encourage you to at least include one, knowledge about the substance. You are very familiar with Title 16 in this room. You all deal with it all the time. And if you look at our simple theft statutes, for instance, theft of stolen property, there is a knowledge requirement even then. Even then, prosecutors cannot effectively prosecute someone for possessing stolen property unless they knew or should have known it was stolen. But here you are willing to, without any intention to kill someone, hold them accountable whether they knew or not what was going on in the substance of the what was going on with the formulation of the controlled substance, despite the fact that the conversation here is clear that you were going after the people who knew or should have known. I would simply encourage you to include, with respect to the containing of fentanyl, there about lines 26 and 27, a know or should have known concept, and couple that with removal of lines 36 through 40, and I am speaking to LC 560173S. I will not take much more of your time. I did want to just address a couple of questions that came up in earlier conversation for clarity's sake. In Georgia, you can receive a life sentence on a drug distribution case, but only on a second or subsequent conviction. It's not on a first conviction. And I have been party to defending a case, Mr. Chairman, where the death penalty was sought in a felony murder case in the Alcovy circuit. It is possible. It does happen. I, unlike my colleague across the aisle, can't tell you how many times members of my organization have been defending against felony murder predicated on 161330, but I can tell you it is happening. It is successfully happening. And it is true that it is sometimes unsuccessful because the courts have said if you're going to take someone's life through the death penalty or through putting them in prison for the rest of their life, in these cases of felony murder predicated on 161330, there's a proximate cause requirement. There's also a knowledge requirement. And I would also alert you to other courts across the country who have overturned drug statutes. For instance, in Washington, just in 2021, Washington v. Blake overturned that state's drug statute for a lack of mens rea. That's all I would bring to you today. Yeah. So in Washington State, this is a drug possession case. Washington v. Blake. It's a 2021 case, and I'm sorry I don't have the site for you, but I can get it for you. But they overturned their possession of drug statute for for being a strict liability crime, merely on possession. So when we're talking about strict liability for death, it ought to give us pause.
Thank you. You have several questions if you can
course.
wait. Chairman Leverett.
Thank you, Madam Chairman. Maisie, what were your two asked? You had asked to delete paragraph F, 36 through 40, and there was one other.
In favor of including a knew or should have known knowledge element with respect to the fact that the substance contains fentanyl. So it could potentially be, and I would defer to Legislative Counsel, of course, but selling any substance, manufacturing or selling any substance that the person knew or should have known contains fentanyl.
As a new paragraph F or somewhere else?
No, it would be up there, I'm sorry. It's up at lines 26 and 27.
Okay.
So 26, where it ends, manufacturing or selling any substance that the person knew or should have known, or such person, I guess, knew or should have known contains fentanyl. With that knowledge requirement up in subparagraph B.
And it would also have to be fentanyl too, correct?
Yes.
I mean, just, it's not like.
Under this piece of legislation.
So it would have to contain fentanyl, and you would have to know it, or you should have, under the circumstances, known that it contained.
Knew or should have known, right?
Okay.
So that should have known, which is, it was discussed earlier, this idea that if you're the manufacturer, I would like to think it would be not a difficult burden for the state to bear to prove knowledge, especially in the manufacturing context. Mm-hmm. Maybe it gets a little bit more difficult in the selling context, but I think even in the selling context, the door becomes open to what Representative Miller was discussing with respect to any kind of intervening cause between the sale and the use that you don't struggle with in the manufacturing context.
How, easy it is to prove. I mean, you're having to prove subjective knowledge of the defendant in that case, right?
Well, so, I mean,
Well, I guess if you got a should have known, it wouldn't necessarily be. It could be objective.
right.
But that's still, I would think, a pretty difficult.
The new is certainly objective. The should have known subjective for sure. Yes.
Okay. So, but again, to that point, that is a bit of a burden, isn't it, to prove that element?
Right.
Okay.
Certainly.
Okay.
This is a murder prosecution.
Yeah, no, I understand. Thank you. Thank you, Madam Chairman.
Leader of Stration.
Thank you, Madam Chair, and thank you, Ms. Lynn, for your presentation. So as I understand it, to prove felony murder currently, you would have to, the causation or foreseeability element would have to be met. You'd also, I don't think you mentioned this a moment ago, and I'm sorry if I missed it, but you would also have to prove that the underlying felony is inherently dangerous as
Right.
well.
Right.
And I think that's from the Ford case, as I recall, as a prosecutor. That's a convicted felon shooting through the wall, and it was the Supreme Court said it wasn't an inherently dangerous, I guess, I don't know, act. So I guess my question is this: do you view this bill more as a lesser offense from pursuit of felony murder, which would be available, as I understand it, under the right circumstances? And therefore you think it would be appropriate to have that discretion for prosecutors, even if it includes F here, which you've characterized as strict liability?
Well, so the strict liability, my concern is more about the fact that you don't have to intentionally cause the death. There's no intent to cause the death. So this is a strict liability murder.
So
Not
I
so much
understand specific intent. We have got a lot of smart folks in the room, so they can correct me if I'm wrong, but the specific intent is not the intent for there to be a death. It's the specific intent to do the underlying felony, which then results in the death. And the question is foreseeability to get to that point. So, so again, it's not about, in felony murder, it's never about the intent to cause the death.
Right.
Well, maybe it is sometimes, but typically it's not. I would think it's the intent to commit the armed robbery or to do the underlying felony, which just results in a death.
Right.
So in my mind, at least, I view this as, this is poison that is being put on our streets right now, and it's when it is including toxic substances like this that cause death with such a minuscule amount that's involved. What other means? What is it other than inherently dangerous, and that death is reasonably foreseeable when it's sold or provided to somebody? I frankly don't understand the controversy around this right now, and I'm wondering, does Gactel view this as a lesser offense of felony murder, and therefore you're supportive of legislation to address this? Or do you think that this is just a furtherance of what you characterize as a strict liability standard?
Okay, several questions. I'll back up and try to catch them all.
Yeah, sure.
So I believe, and I would need to go double check my computer, but that our courts have determined that the sale of drugs is inherently dangerous. So on that, in the felony murder context, that's part of how there are these successful prosecutions of felony murder predicated on the sale of drugs.
As I understood, it's case circumstances dependent, but you very well could be right.
But there are more. Well, there's more than just the inherently dangerous, right? There is a proximate cause aspect to it too. So, it's
The
not
foreseeability.
simply. Yeah, it's
Yeah.
not simply the fact that it's inherently dangerous. Certainly. Does Gactel see? So, with a lack of mens rea with respect to the substance in issue, the drug in issue, and then without the, let me back up and say, I agree with you on felony murder. Yes, you don't have to intend the death. You have to intend the act that causes the death. So here, you not only don't have, you also don't have to intend the death here. So Is that why you're asking if I think it's like a lesser included?
Yes, so I'm wondering, do you prefer that this be in code so that felony murder would not be pursued in these types of cases?
And I think felony murder is a reasonable pursuit in these cases.
Oh, you do? Okay.
Yes. My preference for a policy like this is to include some aspect of mens rea, especially when you're going after the people who are in the best position to know or should know that the substance is fatal.
If you think felony murder is appropriate, if the facts fit the circumstances, then do you see the need to address this with a separate aggravated involuntary manslaughter?
No, I don't.
Okay. All right. Thank you.
All right, that's all the questions I see. Thank you.
Thank you.
Anyone else sign up? And I'll give you time. Anyone else would like to speak to this bill? If I'll give you, if you can.
I think one thing that dawned on me, sitting back in the back of the room, is that the year after the amnesty law passed, I went up to UGA to speak to freshmen to talk about this, and every single hand in that room shot up. At fraternity, basically IFC, they kind of have a big meeting about stuff. Everyone knew about this. So I think some of the things I'll say is I will put in the time to make sure young people, I work with the advocates behind me, that there is understanding of these two things can cohabitate in some ways if we craft it right. And so I think it just speaks to the fact that this is in some ways, having worked around public health communications, a communications issue just as much as it is a legislative criminal statute issue. That's it.
Thank you. Ma'am, did you want to speak? If that's okay. Sure. Oh, sure.
Thank you for this time. My name's April Biagioni, and I am a public health prevention specialist. I've been working in overdose prevention and for several organizations, and my heart goes out to all of those who have lost loved ones to this epidemic. I myself have been touched multiple times by family members and friends, but also at the same time, I'm really commend the efforts of those here in harm reduction that spoke. And so across the country, there's been a surge of fentanyl-related legislation at the state level, including the possibility of pursuing murder or manslaughter charges against dealers linked to fatal overdoses. However, I argue that such punitive measures could blur the lines between justice and vengeance, potentially condemning those with opioid use disorder to lengthy prison terms and discouraging life-saving interventions during overdoses. I thank you all for the legislation that y'all passed with amnesty, but that is also up now because with these kind of laws that are trying to charge people for manslaughter, it's really going to blur those lines. The 50-year-long war on drugs has been a tremendous failure in this country, and the punitive approaches to drug offenses, noting that despite increased incarceration rates, drug use remains widespread. The disproportionate impact on drug laws on marginalized communities, exacerbating cycles of poverty and unemployment, particularly among those people of color and in rural areas. These are not your party goers. These are people who have substance use disorder in rural communities that don't have access to care, to mental health care, to substance use treatment. And so instead of focusing solely on supply side interventions such as border control or harsher sentencing, I urge you to call for a shift towards demand side solutions. So I applaud, some bipartisan legislation like Mainstreaming Addiction Treatment Act, which expands access to medications like buprenorphine and opioid addiction treatment, and the FDA's approval of over-the-counter Narcan to reverse overdoses. So I just hope that y'all take that into consideration. Thank you.
Thank you. All right, Senator Goodman and Dee Cranford, can you guys come back up? And I'll give you a little bit of time to respond or say any closures. I think we'd like to also hear, and we keep going back and forth with the questions as far as, why is this legislation needed right now when we have the felony murder statute? And if you can try to give us a little bit more on that as well.
I'd
Thank
be
you.
glad to. And I start off and say this bill, originally it had the mandatory minimum in it. We took that out before we went into Senate Judiciary. The bill passed out of Senate Judiciary unanimously, and then it passed out of the entire Senate body with only 3 no votes. Senate Bill 465, which is Lieutenant Governor's bill, Austin's law. I've heard some of the testimony here, words like justice and vengeance, and if we're going to take someone's life, talking about life in prison. I guess I'm here. I'm a voice for Austin. I'm a voice for Jack right now. Where is their voice at? That's where I guess I get frustrated. When we came here, I worked with my dear friend Whit Burchett. We took out delivery and distribution. We focused it completely on fentanyl. But y'all, the deterrence that we've got out there is not working. It's not working because with felony murder, they could hide behind saying, "Oh, I didn't know it had fentanyl in it." But when we know that over 70% of the drug-related deaths are attributed to fentanyl, the people that are selling this stuff, they know dang well that there is a good chance that it could be laced with fentanyl. That's the point of this. That's the point of this bill. My daddy used to say, if it walks like a duck and quacks like a duck, there's probably a duck somewhere. That is the point of this bill. If you're selling these illegal drugs, you know that there is a good chance that it could be laced with fentanyl, and the deterrence isn't working. And I'm hoping that this bill is going to save lives. I understand where people, the testimony that we've heard earlier, but it's only getting worse. I'm hoping this legislation is going to save lives. We've worked in good faith with everyone. Like I said, the bill passed out with only 3 no votes in the Senate, and I've worked with Whit Burchett. I feel like I think we've got a good compromise. But the number one thing to me is just like Angela and Stephanie and Christy and Beth and Rhonda and all these people that are sending me these emails that are losing their children to this fentanyl epidemic, that these people that are spreading this poison will not be able to hide behind any longer, "I didn't know what was in it." Because they know dang well if they're selling it, there is a very good chance that it could have fentanyl in it. That is the purpose of this legislation. And I guess with that, I'll let you answer the legal questions. But I do hope that this committee will move this legislation forward. I hope you'll move it forward in Austin's memory and Jack's memory and all the other people that have lost their lives to fentanyl.
Thank you. All right, I don't see any more lights. Or one more, leader abstration.
The appropriate time, have a motion.
D. Cranford, did you want to say anything and respond?
Yeah, I think to add a should have known element would basically render the whole statute moot. To be honest, I think that's the whole point of this, is capturing, the large majority of these fentanyl deaths where there just isn't the evidence to prove beyond a reasonable doubt that the dealer knew or even should have known there was fentanyl in it. And that's why we have a broad punishment range, in my view. There's a lot of discretion that the elected DAs and the elected judges can apply based on the facts and that dealer's respective culpability. I do think sometimes life will be appropriate. I think there'll be plenty of times where something less is appropriate. But if we insist on proving beyond a reasonable doubt that the dealer knew there was fentanyl, my great concern is, we're going to stay on the same track of maybe prosecuting a handful of felony murder fentanyl deaths a year when, you know, there's thousands of people dying a year. And I think this is, as I see it, this is the tool we need to hold more dealers accountable for all of these fentanyl deaths. And I mean, as a prosecutor who's been doing this for a little while, I would really like to have this tool.
All right, thank you. All right, Leader Registration, did you have a motion?
Move to pass.
All right, so we have a motion and a second. Do we have any amendments?
I do, Madam Chair.
Sure.
So if I could just pass this around. While it's going around, I'll just describe it. This is a very important underlying bill, and what I wanted to do is highlight some great work that Representative Derek McCullum has done in the House this session, and I know he's been working on this for the past year. And this would make it illegal to have a pill press in Georgia unless you are authorized to do so. As was mentioned previously in by one of the members speaking to this bill, you know, when you take pills, I mean, there's nothing that could be more dangerous to you if the substances aren't right as to what's in them. And it seems to me that this legislation matches up very well to Chairman Goodman's excellent underlying bill. And so I appreciate the committee's consideration of this. You'll just see that the operative language begins in line 32. If you would just disregard the substitute bill number at the very top, it would be an additional section here in SB 465. But the operative language is on line 32, that it's unlawful for any person other than a regulated person to possess, purchase, deliver, sell, or possess with intent to sell or deliver a pill press or tableting machine. And you can see all the definitions are in there, including regulated persons. So folks who have a legitimate reason to have pill presses, they're covered. And this is a very important public safety measure, and I think that it goes very well with this important underlying bill. I want to thank Senator Goodman, District Attorney Cranford. I want to thank Representative Derek McCullum for his hard work on this issue over the past year. This is, I'm just presenting the fruits of his investigation and very hard work. So my motion, Madam Chair, is to add this language, LC 481287S, as a section into Senate Bill 465. Thank you.
All right, Chairman Smith?
I'll second the majority leader's motion.
All right, thank you. We have a motion and a second on Leader Registration's amendment to add the language that was passed out. All those in favor of, I'm sorry, Whip Burchett, did you have a question? Yeah. Sure.
Yes, I'm friendly to the amendment. I just want to make sure there's some conflicting terms in here. For instance, we have controlled substance in here twice, and I want to make sure that we aren't going to add conflicting terms. It says so on line 14 in the amendment, we got controlled substance has the same meaning as provided in 161321. And this one says, but shall not include marijuana as defined by such code section. It was the exemption of the marijuana for the fentanyl piece. So, do you think that causes conflict at all, or do we need to? How do you see that, Mr. Leader?
I'd strike from my amendment line 14, so that there's no issue there.
Oh, are we setting it in here as a second section?
Yes.
Correct.
Okay.
Yeah.
All right, so it doesn't speak to the section. Okay, that clears it up for me.
Correct.
I don't think you need to strike it then.
Correct.
If it's going to be what I understood your amendment to read as putting it in the same section. So I'm good with that if it's going to be in a total separate section. So it would be a new section 3. Picking up after lines 40, and then the current section 3 would go to section 4, and then the next section 5, right?
That's right.
Okay,
yes,
thank
sir.
that and disregard what I said. Thank you, Mr. Leader.
Correct. All right. Chairman Leverett?
And I was was just gonna add, that was my,
Yeah.
not so much that it's a new section, but you're creating a new code section by the amendment we're making, so the definitions are limited only to the section in which they
Correct.
appear. I don't think there's any conflict at all.
All right, that's correct. Okay, with that clarification, all those in favor of Leader Abstration's amendment, say aye.
Aye.
And I think that's unanimous. Any other amendments? Chairman Smith?
Thank you, Madam Chair. Looking to line 29. I would strike from the word imprisonment down to the period at the end of line 30 and insert the following starting with shall be punished by death or imprisonment for life or by imprisonment for not less than 15 nor more than 30 years, period. None of this sentence shall be stayed or probated.
All right, that is Chairman Smith's amendment. Do we have a second?
Yes, I can read it again if the. Okay.
Did you want to repeat? Okay. Chairman
Okay.
Smith?
All right. Shall be punished by death or imprisonment for life or by imprisonment for not less than 15 no more than 30 years, period. This sentence shall not be stayed or probated.
Do we have a second on Chairman Smith's amendment? All right, all those in favor of Chairman Smith's amendment, say aye. Sure, we can, I apologize. All right, any discussion on Chairman Smith's amendment? Leader Abstration.
So I have some questions for you, Mr. Cranford, if you're able to explain. Can you give to me the state of case law currently on, from the U.S. Supreme Court on imposition of the death penalty for non-murder offenses? Because my understanding is we've got 7 offenses in Georgia that have the death penalty, but it is not available for sentencing except for murder due to U.S. Supreme Court case law. Is that right?
Haven't felt like this since law school. With the giant caveat that there are smarter people than me to answer this question, off the top of my head, I think there may be a proportionality issue. This does cause a death, but this is manslaughter versus murder, if that's what you're kind of referring to in terms of the Supreme Court. 2, I would really have to look at what is currently in the statute for the death penalty and the statutory bases to pursue death and compare them to this. So I can't sit here with confidence and say that the facts we're seeking to punish and hold accountable with this statute would comply with what's necessary to meet the statutory factors to pursue death. Those may be incongruous. I don't know as I sit here.
Well, I don't either. And I think I probably am going to need to study this issue because I haven't thought about this. I haven't thought about application in a circumstance like this previously. So maybe if you and I could talk offline so that I can learn about this, that would be helpful, and maybe it'd be helpful to the members of the committee here as well.
It would be helpful to me, yeah.
And I agree with you, Leader. If I can have Robert Smith come up with PAC. Sure. Would you be able to speak on Chairman Smith's amendment?
Certainly, thank you. Robert Smith, General Counsel at the PAC. To answer your question, because of the way our death penalty statute is set up, you have gone in, first off, for a prosecutor to seek the death penalty, in the statutory notice and then proving we have to allege certain statutory aggravating factors. But the other more pressing problem is 171030, which delineates out how the crime was accomplished. Now, if you want to take this, I know that there's the senator has offered up, and what's been discussed is a separate crime that's found in the homicide chapter, 16.5. If you wanted to dump this in to second degree murder, that would then solve the problem that just got created with the imposition of the death penalty, because murder is included in 171030. So that, and by the way, some of the discussion before the amendment to include death, the same punishment range in second degree murder was what was the sentence range for this aggravated involuntary manslaughter. So that's one of the things to consider and think about. And I'm not advocating a position. Mr. Cranford is here. He speaks on behalf of the DAs when he's in the room. I'm just here answering questions. Anything I say that is not in opposition to the position of the District Attorneys Association of Georgia. This is just answering a question I've been posed. That's all the caveats I've got to get out of the way real quick. But you already have a murder statute, and in your murder statute several years ago, you threw in second degree murder. So if you wanted to dump this crime in as an additional way to commit second degree murder, you would solve the problem that was just created by putting death in. Long answer, but that's the answer.
All right, Chairman.
Thank you. So let me just understand what you're saying. There is a way to still keep this stiff penalty if we put it in that section instead.
If you moved it over, but then there may be some other unintended consequences, and that would be part of a longer conversation. But right now, aggravated involuntary homicide, aggravated involuntary manslaughter is not an authorized crime in the state of Georgia to seek the death penalty for. So you'd have to go into Title 17 to authorize it as well. But murder is. And murder already exists in your code sections.
I'll withdraw my amendment this time just for members of the committee. I do think I'm going to look at including this in the other section. My whole fear the whole time, just for the senator, just know my heart. I want to see him down in Jackson. I want to see that ultimate penalty for him for dealing this deadly poison. That's the intent of my whole position here today, so just so you know that. And if we can achieve that, we'll do it, but I'll withdraw my amendment at this time.
All right, thank you. All right, any other amendments? All right. You do have an amendment?
Yes.
Representative Miller?
So I would ask that we consider at line 26, after the word that, the phrase such person knew or should have known contains fentanyl. And I would move that we strike lines 36 through 40.
All right, we have a motion to amend from Representative Miller and a second. Do we have any discussion? Whit Burchett.
Thank you, Madam Chair. Just a question about the amendment. What is it we're, as I understand what we're doing here is trying to get after these folks that have manufactured or sold these drugs. And then the excuse of not knowing is what they are able to get out of a felony murder for. And to Representative Roberts, I was trying to figure out if knowing that and knowing that if they knew or should have known, you can go after them with a felony murder, then that would essentially just turn this into a felony murder statute. I just wanted your thoughts on that.
Well, thank you, Mr. Whip. I agree with everything about this bill and what we're trying to accomplish. My concern is with either the complete strict liability, which if someone's manufacturing it, this is a non-issue anyway, because they're manufacturing it and they would be the most culpable. The concern that was raised about people who are substance abuse addicted, who sometimes sell things that they've purchased, and criminalizing those individuals in the same way as we would a manufacturer. I feel like this, either we just do manufacturing or we add some sort of negligence, recklessness component to the mens rea if the penalty will include a life sentence. I just think that that balances out the way that we have traditionally treated manslaughter offenses. There is a substantial imprisonment component to this, which I support. But I just believe that in fairness, so that we don't get upside down with this, that we add some semblance of a should have known component that I think we don't have to worry about anyway when we're dealing with a manufacturer, people who possess these pill presses and the like.
This is a question for the author. Isn't it your intent with the bill to get after the folks that are hiding behind the fact that they didn't know? Yes. All right. Well, thank you. I appreciate it.
Representative Byrd or Chairman Leverett?
I think that my question just got answered. I was going to ask if the author considered this friendly or not, and I think you just answered my question.
No, sir. I think that the work that has been done by myself and Lieutenant Governor's office, Brian Strickland or Senator Strickland and the Senate Judiciary Committee and our body has been to address there again that you can't, with the fentanyl epidemic raging across our country, that people cannot hide behind saying, oh, I didn't know that it had fentanyl in it, because the chances are very great that it could. And so that's the intent of this. Go ahead.
And if I may add, just speaking to the representative's concern, this is a huge punishment range, and I think the minimum would be 10 years probation, in a very, very mitigated situation. And I would remind everybody, there's going to be two layers of discretion at play here. There's the elected DA who's deciding to even bring these charges and what sentence to seek, and then there's going to be a judge who's hearing all those facts and the mitigating facts from defense counsel and defendant. So I think those are two layers of protection that speaks to what I understand to be your concern that isn't in the language of the bill, but it's there. And knowing DAs, I think there are plenty of cases that they're going to feel like Chairman Smith feels, and maybe you feel that a life sentence is appropriate. But I think there's going to be plenty of cases where, like my office decided it deserved, a 30-year parolable prison sentence, or like Harrelson DA's decided it deserved a 15-year parolable sentence.
All right. Any further discussion on Representative Miller's amendment? Okay. All those in favor of Representative Miller's amendment say aye. Aye. Those who oppose say no. No. All right. It fails. Any other amendments? All right. Any further discussion? So we have SB 465 with Leader Evstration's amendment that we are considering with a motion in a second. All those in favor of voting on SB 465 with the amendment say aye. Aye. Those opposed say no. All right, it passes. Thank you, Senator. Thank you to the families that were here. Thank you. All right, next bill is Chairman Strickland, SB 533. Good afternoon.
I just presented two other bills while I was running back and forth waiting on y'all, so it's been good.
Well, you're used
I
to
have a lot of
judiciary.
breath. I bring y'all Senate Bill 533, and this bill comes on behalf of DBHDD, particular Commissioner Tanner and the Forensics Work Group, our Behavioral Health Reform Innovation Commission that was led by Judge Gosselin up in Hall County. And we are addressing the issue of jail-based restoration. And so we're in the area of law where you have individuals that have been found to not be competent to stand trial. And so by law, current law, DBHDD is charged with restoring those individuals so they can face the charges that they have against them. The issue we currently have is lack of hospital state beds available. And so we have individuals sitting in jail waiting for their chance to be restored so they can face the charges they have against them. The thing I've heard is you have people that are sitting in jail longer waiting to face charges than they would actually spend if they actually faced the charge and were found guilty. And so we currently have an average wait time, at least when I filed the bill, of 275 days for a hospital bed to be open, with 617 people at the time on a wait list. So all this bill is doing is codifying the practice of jail-based restoration, where DBHDD can go into a jail only under the authority of a sheriff with an agreement entered into by that sheriff, and complete that restoration while the individual is still incarcerated versus waiting for a hospital bed to be opened up. And so that is all this bill is doing. And there's folks here that can testify more about this. There's currently, I think, 3 pilot programs where DBHDD has started doing this in our state and had success with it, and this would codify that to allow this to happen everywhere in our state. Happy to answer any questions.
Thank you. And I certainly have seen this in my own practice, so I think it's a thanks for bringing it. And any questions from members? Representative Byrd.
Thank you, Madam Chair. I want to be sure I understand what I'm voting on here. So if someone has been incarcerated because of whatever reason, the judge has ordered that person for X amount of time, we are now going to vote for someone from a DBHDD to go into this prison system to treat that person.
No, so this is someone that has not been found guilty of anything. They're currently being held on charges, but they have been found by a court, and there's a process for this. Someone can weigh more in on this. They've been found to be not competent to even face their charges. They don't have enough competency to work with their lawyer and defend themselves. And so by law, that person then has to be restored by DBHD, all existing law. And the current law has that person waiting for a hospital bed. And so they're sitting potentially in jail still if they can't otherwise get bail. I guess they couldn't get bail anyway if they're not competent, but someone can comment on that. But they're waiting currently for a hospital bed to open up for a restoration process. And this would actually just allow DBHCD to work with a local sheriff to go into that jail and complete that process there to speed it up versus waiting for a bed to open up.
Thank you.
Whit Burchett.
Thank you, Madam Chair. Thank you, Mr. Chairman, for bringing the bill. I much appreciate you coming on this side of the
Happy to be here.
The building.
Y'all take as long as I take. So
I know. You've got patience. So essentially, this is an efficiency to get folks that are bound up in the system released and moving and passed through the system, right?
That's correct. Yes, sir.
All right. Very
That's
good.
What I should have just said.
Thank you very much.
Thank you.
And Representative Byrd, I think, so in my practice, I've seen where I may have somebody that I was appointed to represent and I'm not able to communicate with them. And so it may be that certain of these people may just need some medication to get them back to normal or to restore them so that they can be competent. And so instead of having to wait for a hospital bed to do that or anything else to get to that point, this bill essentially will make it where they can go into the jail and actually do that. Is that correct?
That's correct.
Okay, any other questions? Okay, and I think we have a few people signed up, so.
Thank you.
I will call up Mike Mitchell with the Sheriff's Association. Good afternoon, thank you.
Good afternoon, Madam Chair. Mike Mitchell with the Georgia Sheriff's Association. I just want to take a moment to share with you some of the concerns that have been voiced by the sheriff since this particular measure has been dropped. We're not here to oppose the bill today, but we do have some concerns, and in its current format, we certainly cannot support it. First of all, it remains unclear to us why we need to codify this language. So as Chairman Strickland mentioned, there are a few sheriff's offices here in the state that have already entered into agreements with DBHDD to administer the InReach program. And we're just not clear why it needs to be codified. It seems like the MOUs are serving their purposes. We're not sure if there's any legal reason why it needs to be codified. We're still unclear in speaking with DBHDD why we need to do that. Several sheriffs have expressed to us that they feel that this measure is a step forward in formalizing jails as mental health facilities. That's certainly something that we do not want to do. Sheriffs have also expressed to us that they feel that this is a step forward in mandating these partnerships in the future, and that's certainly something that we do not want to see happen. Jails are not ideal for restoration services. And that's one thing that we definitely want to make clear to the committee. By their very nature, jails are highly restrictive, they offer limited integration, and that they are more security focused than they are therapeutic. They are places of confinement, they're loud, they offer minimal privacy, and many here throughout the state of Georgia are understaffed, and most do not have available physical space to dedicate to restoration services. Jailers are not treatment providers. Jailers lack advanced training and expertise that treatment providers have, leaving jailers ill-prepared and ill-equipped to deal with inmates who have serious mental health issues. Fourth, because jail InReach programs are such a novelty, especially here in the state of Georgia, there are some constitutional concerns about holding someone beyond the time that they could be released or get community-based restoration services. There are some ADA concerns as well. So in closing, we would just implore the committee to take some time to research some of the legal concerns for the jail-based restoration programs, take into consideration some of the concerns that the sheriffs have expressed to us. We would suggest a sunset provision on this bill. We have offered to DBHDD a 3-year sunset provision. We think that's fair. We think that's reasonable. It would incentivize DBHDD to work toward constructing more bed space over the next few years. So we would just ask for the committee's consideration to include a sunset provision on this particular bill. So members of the committee, Madam Chair, that's all I have. I will yield for any questions.
All right, Chairman Leb.
Thank you, Madam Chairman. Thank you for your testimony. Certainly appreciate hearing from y'all.
Yes, sir.
On the bill. I sense that a big part of your concern was that you don't feel like your members' jails are always necessarily well suited to provide what is referred to here as a jail-based competency restoration.
Yes, sir, Mr. Chairman. If you think about jails, they're designed as places of confinement. They are not conducive to therapeutic restoration services. And we just want to caution the committee about a one-size-fits-all approach with this. Most of the jails throughout the state of Georgia cannot accommodate this jail InReach program.
Well, and thank you. I think
Yes,
that's
sir.
good to know. Do you interpret the bill as compelling every jail to provide jail-based competency restoration?
No, sir, we don't. But we are concerned that it is a step in that direction.
Well, well, and I guess, and so that, again, it's good to know that you have that concern, because you're the guys who kind of where the rubber meets the road. But as I read the bill, you'd have to enter into an agreement to be obligated to provide and perhaps I'm reading the bill incorrectly, but it just refers to it. It says that jail-based competency restoration, the term is defined as clinical services for competency restoration that are provided in jails to persons found incompetent to stand trial pursuant to mutual agreements entered into between sheriffs and the department to offer the clinical services in jails. So as I read it, if you don't have an agreement, you're not providing the jail-based competency restoration. Is that, do you not read it that way?
That's correct. You are correct.
Okay. So, all right, I guess are you sort of concerned this is a slippery slope, that the next year we're gonna come back and mandate that you do it regardless of whether you have an agreement?
I think that is a concern. I mean, it's currently being done by MOUs, and I just don't know why that is insufficient. We don't understand why there's a need to codify this.
Who is the MOU with? DBH,
DBH,
et cetera,
That's right.
letter. I think that's a question maybe we can ask the sponsor, but I just would think you always like to have statutory authorization for whatever practice you're doing to sort of insulate you from liability, and it would seem like this might be a good step in the direction of protecting those jails that do have such MOUs. Any thoughts on that?
None in particular.
Okay, all right. All right, well, thank you, and thank you for your time today.
Yeah, thank you.
Thank you. Representative Crowe.
Thank you. Most of my questions was going to be what Chairman Leverett's already kind of covered, but one part you mentioned about jails not being good locations for treatment and restoration programs and things like that, and I agree that jails are not the best places. I've worked in jails, and they're not the best places to be for people that are needing mental health treatment. But it seems to me that these folks are going to be in the jail anyway if they fell under this program, because they've been found incompetent to stand trial, and they obviously can't get out of the jail, otherwise they wouldn't need a jail-based treatment program. And if they are incompetent to stand trial and they're waiting for a hospital bed to get treatment, then they're going to have to be dealt with by the jailers in the jail housing these folks until that bed becomes available. So I would think I would rather somebody with expertise come in and try to do some sort of a treatment program to help with the mental health issue they're having, rather than me who's not trained to do that. And that's just my opinion on that. And I do agree with him. I would understand some of the concern about this being mandated, but it says in here very clearly that it's a mutual agreement. And so I think if we ever came back and somebody tried to come in and take that out and remove that mutual agreement, that would be a time for us to be able to make sure we don't mandate things on the sheriffs. I certainly don't want to cause them any more work than they're already doing. But when I read this and when I think about it, I think from a jailer standpoint, an employee in the jail, that this might be a benefit, because we've had situations where I've been in jails working, and you had people that were obviously needed mental health treatment, and we were not well equipped to do that. So the sooner we could have gotten them treatment, I think the better it would have been for us.
Thank you, Representative Crowe. And if I may just add, I think the way that the system was designed was that when someone was deemed to be incompetent to stand trial, then they would be turned over to DBHDD, where they would go to a secure facility and they would receive the specialized treatment and restoration services at a secure facility run by DBHDD. The issue that we have, however, is there has been no new bed space. So we're sort of between a rock and a hard place, where DBHDD is having to find some means of being able to meet their obligations. This just happens to be it. So I think the ideal scenario is for DBHDD to bring more beds online. And again, going back to the sunset provision, if we could do the sunset where they could work toward that, where we could have sort of like a date definite where we could expect to see that. So this is not a long-term solution.
Yeah, and I completely agree with you. We have a severe lack of bed space, and I think that's something that we're going to have to look at. And I don't want the jail to become the de facto solution, instead of doing more bed space, to say, well, we can just have the jails and leave them there. That's not my intent. I don't think that's best. I think best would be more bed space where they can get moved out of the jail immediately once they've been found to be incompetent to stand trial. But in the interim, I think this is a solution, but you are absolutely right. We do need to work on making sure there's more bed space. That's the best solution. And to the sunset, I think these mutual agreements, I think without us putting the sunset in, I think that either with it or without it, the sheriffs are going to be able to, in these MOUs, they're going to be able to dictate how long these are for. They could be 1 year, 2 years, however long the sheriff wants to enter into this agreement. So I think the mutual agreement part really covers a lot of that for me, but you are absolutely right. Thank you for bringing up the lack of bed space, and that's an issue we need to address.
Appreciate you.
Thank you. And Whip Burchett.
Thank you, Madam Chair. Thank you, Mr. Mitchell, for your testimony. I'm reading on line 17, and will you explain to me how does it work currently? Like if you have an MOU and the department sort of chooses you mentioned them actually, and this may be a better question for the author, but I want to see if you might have practical knowledge of it. So when the department has an inpatient treatment center in a secure facility, do they come and get the defendant and take them away and treat them there and bring them back, or how does that work?
So it requires a transport that's conducted by the sheriff's office to one of the secure locations. As you can imagine, with the lack of bed space, sheriffs are having to travel great distances to locations that do have available beds. But we are working with DBHDD to do we were doing a transport study. I'm not sure where we're at with that currently, but where DBHDD could assume some transport responsibilities. So we're very grateful for that, grateful that they have brought that to the table to help out with the sheriffs. But currently, it pretty much falls on the sheriffs to do the transports to the secure locations.
Yeah, I would be with you in trying to figure out a solution for having DBHDD do some of that transport, so it doesn't take up your guys and such. And then, so I guess, are you currently seeing the department sort of utilize your space to perform these jail-based competency restorations? Are they doing it now with these under these MOUs?
Yes, sir. So 2 counties in particular that immediately come to mind, Cobb County, Chatham County. Cobb County actually has some space within the jail that's completely dedicated to providing these services. So they have the physical plant there and the staffing to do that. Chatham County, they actually do evals and restoration within the jail setting. They have some space dedicated. The only difference with Cobb County, they just do the forensic evals. So they just partner with DBHDD to do the forensic evals. They're not doing the restoration services in Cobb County.
And then ultimately, and this is my last one, thank you for indulging me. In the event that they get to a restoration, does that then give the defendant an opportunity to have their day in court and then be adjudicated and move on to another facility, or be probated and released? Is that what generally happens?
Yes, sir. So it's my understanding that in Chatham County, once the defendant reaches the point to where they are considered to be restored, they will work expeditiously to get that defendant into court. And then, of course, based on the outcome of the case, they may move on to corrections or be released.
Thank you, Ms. Mitchell.
Yes, sir. Thank you.
All right, I think that's all the questions we have. Thank you. James Woodall.
Thank you, Madam Chair, and to the members of the committee. James Woodall from the Southern Center for Human Rights, and we come just to voice our support for the legislation. I want to first acknowledge our Deputy Director, Atia Holly, as well as our investigator in our Capital Litigation and Impact Litigation Unit, Kirsten Wilder, who have been actually doing a lot of work on this front. There were concerns about potentially moving people through the process of competency restoration for the purpose of just getting them to trial and getting them out of the system. What I'll raise is that in the spirit of the question that we just had, Chairman Strickland actually raised this in the Senate side, but it takes on average about 275 days for someone to get a bed, quote unquote. And so right now, before we even have this bill, there are already constitutional concerns about a person waiting on competency restoration before they're even adjudicated guilty of any kind of offense. I'll also reference the Behavioral Health Reform and Innovation Commission's report that they issued in 2022. And I'll mention specifically Recommendation 16B, Recommendation 18, and Recommendation 23B as well, to really talk about some of the things that you mentioned, Representative Crow, about this being step one of a larger conversation about what does behavioral health look like in the state of Georgia, particularly as it relates to the criminal context and what that does for a person who is standing accused of an offense in the state. And so we do recognize that there is more work to be done here. We do not believe that this is a step in making jails the de facto mental health facility. In fact, we stand opposed to any legislation that would do so. But we do not believe that this is what this does. It is a small but very important step in starting the conversation. And so with that, Madam Chair, again, we stand in support of this legislation, and thanks Chairman Strickland for bringing this bill.
Okay, you have one question, Chairman Leverett. Or, I'm sorry, Representative.
Thank you, Madam Chair. Just curious, how many people are deemed incompetent that we have in our jail system now? Do you
I
have
do
a
not
number?
have, Representative, I do not have that information, but I'm sure our sheriffs or our prosecutors may have that information. You know?
Thank you.
I'm not sure.
Michael might have it. I don't know. I'll chase it for you right now.
All right, thank you. All right, Chairman Strickland, if you want to come back up, I'll give you some time to respond if you'd like.
I'll be very brief. I can't disagree with anything that's been said. The intention of the bill is to give another tool out there now for the department to move these people along to having a chance to face the charges that they face. The other option is to keep sitting in jail, waiting for your chance to be restored to face charges. And so I think this is, as the last speaker said, one step of many as we continue to try to do a better job in our state of dealing with mental health in our state overall. And so I'd rather not have a sunset, because any bill we have could be sunset next year if somebody files a bill and moves it. And I do think we want to have larger conversations around this issue, but it might be that we want to always have this as an option. At the end of the day, I was not willing to carry the bill unless it was something that a sheriff had to consent to, because every jail is different, every part of our state is different. Everybody's not equipped to handle this, and so that's why it's important that we have the language in the bill that says it has to be by an agreement between the sheriff and the department. And so happy to answer any more questions. I don't know if I stalled long enough for Michael to get the answer to that question. But there's, I know the number, I think it was, I had a minute ago, of we had 617 people, the last count we had, waiting.
As of last week, 636.
It's gone up.
20 people since we introduced the bill.
636 people currently are sitting in jails in our state waiting to be restored so they can face the charges they have against them. This will help speed that up.
All right, thank you. All right, what's the will of the committee? All right, we have a motion. Second. Any discussion? Any amendments? All right, all those in favor of Senate Bill 533, say aye. Aye. All right, it's unanimous. Passes. Thank you. All right, I see Floor Leader Bo Hatchett will take up your bill, SB 493. Good afternoon.
Good afternoon. Thank you, Madam Chair, members of the committee. I'm here to present Senate Bill 493. What this bill seeks to do is kind of hone in on how technology has outpaced our criminal code, when the limitations on what sexual, or those who are on the register of sex offenders could and couldn't do were put into place. Drones weren't a thing, and now they're pretty prevalent. Over the summer, I read several articles where sex offenders were using drones to take photographs and videos of individuals without their consent. What this seeks to do is, number one, it strengthens the penalties for photographing minors without the consent of the parents or guardians. And second, it makes it a crime to photograph someone without their consent with a drone if you're a registered sex offender. Third, it also gives the judge discretion on whether or not to include in the in their probation whether or not to prevent them from possessing, owning, or operating an unmanned aircraft system completely. So it would leave it up to the judge if they wanted to just ban it, depending on a case-by-case basis. But received bipartisan support in the Senate after some amendments were made on the floor, and I think there was only one no vote. But this is a bill that I think is necessary to protect children and those that are vulnerable in the state, and would be happy to answer any questions.
All right, thank you. Any questions? I do not. Chairman Leverett.
Almost made it, Madam Chairman. Thank you.
So close.
So I see we're basically, it's currently a crime for someone on the registry to photograph a minor without the consent of the parent or guardian, and that's a misdemeanor of a high and aggravated nature, and we're just making it clear that even if you don't photograph them, if you're sort of following them or tracking them with some kind of drone, that's a crime as well. Is that right?
So it is a crime right now, yes, to photograph a child without the consent of the parent, but drones or unmanned aircraft aren't necessarily contemplated in this
Covered
statute.
by the existing statute.
So what we did was we made it a harsher penalty for someone who photographs a minor that commits basically a second offense. And then it goes into, if you're using a drone, it makes it a crime to photograph a picture of anyone, or photograph anyone, not just children, without their consent, if they're in an area where they have a reasonable expectation of privacy.
And then I guess you're adding also, if you're on probation if you're on the registry, you can't own one of these aircraft.
Right, and that is...
As a condition of probation.
It's a condition of probation, but it's one that is not a mandatory condition. It's kind of one of those discretionary ones that a judge...
Okay.
Correct.
Thank you very much. I think it's a good bill.
All right, you had several lit up, and now I don't see any more. So any questions from members? Any more? All right. We have one person signed up, so Maisie Lynn. Thank you, Leader.
Thank you so much. I will just preface this comment with the fact that it's not friendly. Although Senator Hatchett is incredibly friendly, he's not friendly to what I am here to say today, despite a lot of patience with my repeated requests that he reconsider. What's happening in the sentencing rubric in this bill, and I'm frankly beginning to see it much more often in the new crimes that are created as well as sentencing rubrics that are expanded, is this idea that the person that is being sentenced has to be sentenced to both prison and subject to a fine. If you look at a majority of our crimes, the sentencing schemes are set up so that the person is sentenced to prison or a fine or both. And that certainly gives the judge discretion to do both and to take into account the fact that, at least as we understand it from budget conversations, 85% of the men and women that are prosecuted in our courts qualify for the public defender, which means they are financially indigent. And in cases like Senate Bill 493, where the fines are at lines 44 and 45, a minimum of $5,000, and again at lines 54 and 55, a minimum of $20,000. And this is on top of, the $20,000 would be on top of a sentence that is a minimum 5 years, thankfully, subject to suspension or probation. But should a person actually have to serve a prison sentence that is somewhere between 5 and 10 years and then get out facing at least a $20,000 fine, it just seems rather impracticable considering the people who are prosecuted in our state. And I think that the same analogy applies at lines 44 and 45. And when you're talking about up to a 30-year sentence and a minimum fine of $5,000, it's just a simple request that, like many of our crime sentencing schemes, you would break it out to afford the discrete prison fine or both.
All right. Whip Burchett.
Hey there. Thank you for the testimony. Do you know how much these drones cost?
I do not know.
They're expensive.
I bet they are.
Very, very expensive.
I bet they are.
Thank you very much.
Representative Miller.
Thank you, Madam Chair. Really quickly, because I haven't experienced this, what happens if a person is assessed a fine at sentencing and they can't pay it? What happens?
You mean post, like, getting out of prison?
Sure.
I mean, so there are, and in these cases here, these provisions that are in Senate Bill 493 do not reduce the judge's discretion to suspend them. So I would imagine that, someone who has access to defense counsel could go back before the court and say, here is the proof of why I can't pay this. Would you please consider suspending it? And then whether or not that proof is sufficient. And then I think depending on the time left on any kind of split sentence, I hate to say that I think it depends on its case by case, but I do think it depends on its case by case. But those would be the variables that that could be manipulated, would be suspension of the fine, some kind of payment over probation once the person's out if they're on a split sentence. But once the sentence ends, I frankly don't know what happens to that fine. If the sentence is over and there's no ultimate payment, I don't know. But I would say, I just wanted to say with Burchett, I would imagine that not every person prosecuted under this is going to actually own their drone. So they may not have had to purchase it. There's no requirement that there's proof of purchase or access to that kind of money on the front end. Could certainly be borrowed, rented, or shared.
Okay. Representative Crowe.
Okay, so are you suggesting that we add another paragraph to this that handles somebody knowingly allowing a sex offender to use their drone to pursue somebody? Would that make it better for you in case they didn't buy it?
Representative, that might be friendly to my friendly Senator Hatchett, not to the Georgia Association of Criminal Defense Lawyers.
All right, you have one more question, Chairman Leverett.
The scenario you have outlined is certainly possible, but I would just think for most people, when your buddy on the sex registry asks if he can borrow your drone, you're probably going to turn him down and say, "Oh, it ain't working that day."
The prudent friend. We don't always have the most prudent friends.
All right, thank you. All right, Leader Hatchett, you want to come back up? I'll give you some time to respond if you'd like.
Yeah, and Maislin and I do work well on a lot of bills together. This one, I'd really like to not have any amendments if possible. I know I've spoken with the Department of Community Supervision in the past, and a fine like that a judge could convert the fine to community service if needed. But I would ask for no amendments, but obviously I'm at the will of the committee and would just ask for favorable consideration.
All right, thank you. Okay, so what's the will of the committee on SB 493? Okay, we have a move to pass and a second. Any amendments? Any discussion? All right, all those in favor of SB 493 passing, say aye. All right, it's unanimous. Thank you. All right, last one is Senator Jones, SB 10. Good afternoon.
Thank you, Madam Chair and members of the committee. I am working off LC 394354S, a substitute that was submitted. That substitute that was introduced, there was two changes, minor changes that was made to the legislation. Over in Section 4, it corrected a reference to accused that should have been defendant. And it removed the option of a court issuing a limited driving permit. Those are the two changes that were made in this Senate substitute. Senate Bill 10 is what I consider a continuation of work that was done 3 years ago that Governor Kemp signed into law, which was originally a Senate bill that I introduced, at least most of the language was. However, when I joined, I said Senator Kemp, Governor Kemp, and signing that legislation, there was some language that had been included in the original bill that he chose not to include in his bill. I've since gone back and, along with getting good recommendations from Judge Jackson, who's with me from the Municipal Court in Atlanta, and come up with what I consider some really critical and important changes to the current act that Governor Kemp signed into law 3 years ago. Essentially, this bill over on line 21 through 37, it speaks of this bill is attempting to address those that are organizing these events, those that are actively participating and knowingly present during these events. We are talking about drag racing and land tracks, as well as posting these kind of events on social media. Down on line 39, it does create a new statute of reckless stunt driving. And I will refer you over to page 4, where the fines, and thanks for the input from my judge who's here with me, have been slightly increased. One other thing of importance to note is on line 87 of this substitute, starting on line 87. Some have said this is kind of a mandatory minimum. It is not. It essentially says that for those that create property damage over $1,000, the first 12 months of their sentence shall not be suspended. And of course, that's at the discretion of the courts. And I believe that's essentially the bill, unless there are some further questions, Madam Chair.
Thank you, Senator. And Judge Jackson, thank you for being here. Would you like to say something?
I would, Madam Chair.
Sure.
I'm here today individually as a judge, not on behalf of my court or counsel. I'm here today because under the present law, I really can't do my job and fulfill the same oath that we all took as elected officials. Our state constitution says the paramount duty of government is to protect public safety and property. And currently, I'm at a loss when we get these crazy dragsters and stunt drivers. If it was cockfighting or dogfighting and you're actively involved, you go to jail. But drag racing, stunt driving, you don't. And these folks are doing this for the audience. And if the audience knows they're going to get prosecuted and you take away the audience, chances are you can make a big dent in this crazy kind of activity. And people get hurt, property gets destroyed, and they've actually blocked off interstate highways in Atlanta, 285, near 675, to do this. And the increased penalties, not only will they increase the penalties, but if you're in our graduated licensing system in Section 2, if you get one of these convictions, you're going to sit out 12 months before you get a regular license. And hopefully this will put a dent in it. Section 4 is something that I need desperately in dealing with extraordinarily dangerous drivers. I've had drivers with 29 tickets, 8 super speeders, 14 DUIs, each ticket worse than the next. We don't have jury trials in municipal court. They don't have them in magistrate or probate court that handle traffic. And when these folks who come in who are regulars, they know the law better than most of the lawyers, and they say, I want a jury trial, which is their right. In Atlanta, for example, we send them to state court. There is a 2-year delay. And these drivers are totally unsupervised during this long period of time. and some of them, frankly, present a very serious danger to public safety. Now, in my 36 years as a judge, I've presided over domestic violence cases. And unfortunately, we kick people out of their own house to protect the safety of the family. And if somebody with this kind of record is so bad, maybe we ought to kick them out of their car to protect the safety of the motoring public. And this bill would allow me to have a bond hearing, say, wait a minute, before we send this case over to state court for jury trial or to Superior Court, some counties don't have a state court, let's stop and take a look at it and balance the defendant's, the driver's need to get to work and so on versus the public need for safety. And of course, if a suspension is ordered when the case gets to the higher court, that judge can always issue a new order. But at some point, some of these folks are so scary that somebody needs to do something. And right now, they are totally unsupervised. And the problem with the bind over statute 40-13-23, it uses the word immediately. And defense counsel say, well, once I ask for a jury trial, you no longer have jurisdiction. Quite frankly, I was holding these bond hearings. I got sued in Superior Court under habeas. They were dismissed because the Superior Court judge says to these drivers, the case was bound over, go talk to the state court judge. They appealed to the Supreme Court. And they also upheld me for procedural reasons. But then in one of the opinions, one of the justices said, we've got some serious concerns about holding these bond hearings. This will take care of those concerns and will protect the public, knowing that it is a very serious balancing act. And whatever the trial judge makes, the receiving court, the higher court, can always overrule. But the times I've had to do this, it's quite frankly, it's a no-doubter. These folks are so bad and so awful. And I mean, I had one kid at 140-something miles an hour, a 19-year-old, while his case was pending, he went out and committed laying drags in Woodstock. That was on I-20 right near here. I have seen more super speeders, dragsters, and stunt drivers since COVID began than I saw in my entire legal career ahead of that combined. That's how bad it's gotten. And this bill is desperately needed for public safety.
Thank you, Judge. All right, we have one person signed up, so we're going to hear from them. If I can, yeah, thank you. Thank you. Senator, you can stay up here if you like. It's up to you. Yeah.
Thank you, Matt. Try to be brief. My name is Ben Lind, and I am policy counsel with the ACLU of Georgia. I'm here to comment on the bill. Senator Jones has been working on this bill since I was working in the Senate Research Office. We don't have any comments about the intent behind the laying drags and the reckless stunt driving. Our concern is specifically with regard to what the substitute has changed to Section 4. I just want to bring us all back to kind of think about the right to a jury trial and how fundamental that is in the United States. The first constitutionalization of a right to jury trial in the United States was in 1606 with the colonial delegation in Virginia. That's 14 years before Plymouth Rock existed, specifically of how important a right to jury trial is. And I've heard Judge Jackson make these references to the issues that he's having in his courtroom, and I am very sympathetic to it. I don't understand how a state court can take 2 years to take a case to a jury trial on a speeding case. When I was a traffic prosecutor, if they were there for more than 2 months, I had not done my job right. And so there's obviously some concerns here. And I don't think, and I don't want to suggest for a moment that Judge Jackson is suggesting this amendment to punish people for requesting a jury trial. However, when we're talking about laws of general applicability, I think there's almost 400 municipal court judges in the state of Georgia. And we know that there are municipalities that, because of allegations and lawsuits, that are getting as much as 25% of their revenue from fines and fees for traffic offenses. And so what we are concerned about with regard to Section 4 is the potential for some judge to have a perverse incentive to suspend someone's or have the specter, the sword of Damocles in a state where you have to be able to drive, to have your license suspended to pressure individuals to not request a jury trial right, to keep things in municipal court. And anything that could be read in a law of general applicability in all 159 counties, all 441 municipalities in the state of Georgia, that this is something that could be used to attack a Georgian's right to a jury trial, something that is so fundamental, is in the fact that, because Georgia is still a state that has all of our traffic misdemeanors as traffic offenses as misdemeanor offenses, that we're just treading into a very dangerous lane if we are proposing a bill where that could be a possibility of how it would actually be used in the long run. So I am sympathetic to what Judge Jackson has referenced. However, I would just posit for this committee that they're not going off into the ether. They're going into a court of competent jurisdiction to try the case. And that it's not just defense attorneys in there, that there are state court solicitor generals, a role that I once had and very proud of that I had at that time, that can look at these cases, and if they are such a threat to the public and they don't need to be on the roads, there are prosecutors in the courtrooms who can make that a pledge to the judge, and judges that can consider their records when considering a person's what additional bond restrictions to put in once that case gets bound over to state court. So this isn't the only bite at the apple. We're just saying that where I guess the apple sampling needs to take place is in a court of competent jurisdiction as otherwise set up by Georgia law. And so what I'm here to ask is, I have no comment on the bill itself. I know Senator Jones has been working on this for a while, but just to ask that if this bill does go forward, that Section 4 be removed. And I'll stand for any questions.
I have a question. Do you read, is Section 4, it's referring to not just drag racing, it's referring to all traffic misdemeanor
That would be
cases,
my read.
is that correct?
That would be my read, Madam Chair.
Okay, and so therefore it's essentially giving a judge to modify any type of bond and suspend anybody's driver's license on any traffic misdemeanor cases.
That would be my read as well.
All right, Representative Miller.
Thank you, Madam Chair. That was my question, but to a follow-up on that, and thank you for your answer. Is this a first offense traffic situation where a person's license can be suspended, or is there some sort of, repeat offender element to it?
I looked into Georgia case law because I was very curious because under this bill, it could be your first offense. I know that's not what Judge Jackson's intention is because that's the examples he cited. But I wanted to go back into Georgia law and actually find out, well, what does it take to suspend someone's driver's license pre-trial? And I found a case, I don't remember the citation off the top of my head, but the case is Nelson, and it stands that while it can't be suspended for any reason, it will be constitutional for any reason given to public safety. It will not be an abuse of discretion for a trial judge to suspend someone's driver's license. So in this case, under the read of this bill, for any reason that someone can say, they were driving too fast, and I don't think they should have a driver's license on their first offense, as that person is leaving their court to go onto a court of competent jurisdiction, they can just suspend their driver's license as they're going out the door. And it's that potential for abuse that I think is so important to think about with regards to this section and whether or not it should be included in what's otherwise a good bill.
May I have one follow-up, Madam Chair? So if a person receives a bond, and a person like I can't remember if it was Senator Jones or the judge who referenced a person who, while they were out on bond, went out and did this thing, would it not then be appropriate for that person who's already on bond to then file a petition and then address the issue? In other words, do we have tools available right now to sort of get at some of the worst of the worst, as opposed to what seems a little bit broad to me?
Absolutely, and that was something that I did multiple occasions when I was prosecuting traffic offenses where if it was a pattern of that same misconduct, alleged misconduct while other cases were pending, a petition to revoke or modify bond was a one-page document that was very easy for me to draft.
Thank you.
All right, that's any other questions? Thank you.
Thank you, Madam Chair.
All right. I'll have the sponsor, Senator, if you'd like to respond. If you'd like to respond, Senator, I won't put you on the spot.
Thank you, Madam Chair.
Sure.
I think I would. My bill is in reference to drag race and land tracks. Is in reference to those that are out there actively participating and knowingly present during these activities. So when you think about the purpose of this legislation and those that are whose charges are being filed under this legislation, it is typically, and I'm a car dealer. I sell cars for a living. I sell really expensive, high-performance cars as well. Those cars are no different than someone having a gun held to somebody's head. They can kill people if they're used it properly. This activity that we're trying to stop in the great state have caused a lot of injuries. And that's the whole purpose of having spent the last 3+ years working on this legislation and trying and get rid of this activity where those that are organized and filming, and all you need to do is Google it, you can see it, or pull up any YouTube and you'll see these kind of activities. The original bill was named after J. Mize that was passed and signed into law by Governor Kemp 3 years ago. That was a young lady from DeKalb County who had been killed. Her mother is Bobby Sanford. Her husband was a commissioner, long-serving commissioner in DeKalb County, was killed by two drivers who was out there drag racing with each other. That inspired me 3 years ago to create this legislation, but I knew it had grown in something much larger with those out there creating an activity online about using these cars in ways they shouldn't be used. Section 4 simply give, as Judge Jackson already stated several times, discretion to deal with those kind of drivers who's using these high-performance cars out here drag racing and laying tracks and creating disturbances in the community. It also gives law enforcement an opportunity to do something to stop it. And I take your eyes back to what I said at the beginning of this legislation, those that are knowingly present and actively participating. That really is the heart of this legislation. And I understand that there are concerns, but that understanding has to be dealt with by those that serve on our municipal courts and even in our state courts. And I think Judge Jackson, through his research in the 37 years he's been on the bench, he can tell you that they do not have enough tools to deal with those few out there that's creating these kind of problems in our community.
Thank you. And Representative Miller has a question.
Thank you, Mr. Senator. I do appreciate and understand the rationale and hard work behind the first part of the bill. My concern, though, is with Section 4 of the bill because it does not seem to be narrowly tailored to address the specific harm of these drag racers because it applies to any traffic misdemeanor and is coupled with this notion that once a person has asserted their right to a trial by jury, which is their right, that one, the court of jurisdiction for that would no longer be the municipal court, and then two, the municipal court would then be taking action on a case that it does not have jurisdiction over, and it seems that that action is triggered by the person's assertion of that right. So my concern, and I want to support this bill, but my concern is with the potential use of this, and I know Judge Jackson wouldn't do this, but you know, we're talking about changing the entirety of our law for courts across this state who don't have the problem that we might be seeing here in Atlanta. Would you consider removing Section 4 of your bill so that we can continue on with the drag racing part of it? Would you accept? How would you feel about that?
Certainly, it's the discretion of the committee, and I would consider it. But what I would ask, though, is that we, if it's not tailored narrowly enough, that we at least reconsider some language. And I would like to consult with my friend back here, Judge Jackson, in terms of what that would look like in Section 4 the committee would allow.
Thank you, Senator. And I do understand, and we see videos and things like this on the news all the time, so I think this is a serious issue. But I do have concerns, same as Representative Miller. So we're going to keep this as a hearing only. I think that Representative Miller would be, willing to help with some language that we can possibly fix on that as well.
Absolutely.
So thank you. Thank you for being here.
You're welcome. Thank you.
And that ends our committee meeting. We're adjourned. Thank you.